CIRP. And to begin with the session, I would first like to invite Deepak Rao sir. On the behalf of ICSI IIP, I welcome you, sir, and I would like to give his brief introduction. Sir is a member of Indian Economic Service. He belongs to 2008 batch of IES. Before joining IBBI in February 2022, he was posted as Joint Development Commissioner in the Ministry of Micro, Small and Medium Enterprise. During his tenure of nearly 4 years in the Ministry of MSME, he had a very diverse portfolio, which include MSME policy, credit scheme of MSME, and marketing support scheme. During his 14 years of career as civil servant in the central government, Sir has also worked in Department of Consumer Affairs, where he dealt with the issue pertaining to price of essential commodities. Ministry of Finance, where he dealt with career management of officers belonging to Indian Economic Service, and Ministry of Commerce and Industry, where he was instrumental in developing price indices or for air, rail, and port service. In IBBI, his profile includes valuation and research. Sir, on the behalf of ICSI IIP, I welcome you and you may please throw some light upon the subject.
Thank you. A very warm good afternoon to all. I think being a chilly day, it requires to be a warm good afternoon. And then I'll directly come to the subject. I won't touch upon the technical aspect because I have seen that Amit Gupta, my friend, is there. I think it's for the third time myself and Amit is in the same panel, and then Mr. Jigar Bhatt is there. So both of them are very renowned speakers on this subject. But what I would like to say is that the basic objective why the IBC was drafted or a law was introduced was to value maximization and the time-bound resolution. Now, if you see both these objectives, the role played by an IP and CoC, these are the two institutions which are supposed to play a key role, and then it's not the individual capacity where they play this role. Basically, it's a partnership-like thing. And when you talk about partnership, see, in a game of cricket, ultimately the partnership shows that the number of runs scored by two different players batting together. So it could be a partnership like Sachin Tendulkar or Virender Sehwag, where both of them are kicking from two different ends. Or it could be a partnership like Kapil Dev and Madan Lal, which went into the record books in 1983 World Cup, where they scored 135 runs, where the one person scored around 110 runs and the other contributed 24 runs. But the role of the second partner was as important as the role of the first partner. So what I would like to say is that here the partnership is there, but we need to have a clear-cut definition of the roles of both the institutions, IP as well as CoC. I think if you read the code along with the regulations made under, there is some sort of clarity, and the emerging jurisprudence is further clarifying it. Of both CoC and IP. There is one particular judgment, although I'm not a lawyer, I don't understand law much, but that has been talked about across uh, the stakeholders. Is that a judgment given by Supreme Court in the case of case Shashidhar versus Indian Overseas Bank, and then two observations which I could understand as an administrator, not as a regulator, being a member of Indian Economic Service. The two observations which I could understand in that particular judgment is that the commercial wisdom of CoC is paramount, number one. And number two, that resolution profession is not required to give its opinion on the subjects which lie in the domain of CoC. Now, there are two particular points which I would like to highlight on this. The first is commercial wisdom is paramount. I think what is commercial wisdom that can be debated or that can be discussed. To what extent the commercial wisdom is there? What is commercial wisdom and what is there which falls outside the domain of the commercial wisdom, number one. And number two, where it is said that the RP need not give his opinion. See, being a student of psychology, I do understand that opinion and the presentation of facts in a very logical manner. There is very thin line which differentiates between these two things. I need not give my opinion, but when I present my facts in a very logical manner, in a very lucid manner, so that is something which should be allowed because a fact pertaining to CD is something which is known to an RP only. A CoC comes to know about these facts through an RP. So an RP, IP, I mean, they need to develop a capacity to present those facts in a logical manner so that the CoC can understand that. That is something which I do understand because these are the two observations where these two connotations, commercial wisdom and opinion, can be debated over time. And then lastly, being a member of a service which deals with the bankers and during my previous tenure, I have been dealing with the bankers only because I was looking after MSME credit. I think here the CoC basically they are financial creditors, and the way the system of credit has evolved over a period of time in our economy, mostly the financial creditors are institutional creditors, they are banks. And when you talk about banks, it's generally the public sector banks. So when you deal with the public sector banks, I have been dealing with them for last 4 years as Joint Development Commissioner for MSME credit. What I could understand is that the system has evolved over a period of time. They have their own conventions, they have their own social behavior, they have their own administrative limitations. So if an IP or RP tries to understand that, he could be in a better position to place the facts before CSC because uh, to be a little more vocal, what I have studied about the Indian banking system is that most of the IPs who are participating in this workshop, they may also have their own opinion. Some of them may bail me out of that. Generally, in CoC, they don't take decisions. They go back to their head office or the regional office, and then they come back with a decision or something like that because that is how the system has been evolved. So, what I would request all of you is that if the facts are presented before them in a manner which would help me take decision, which would help them take decision and explain the situation to the seniors in a better manner, that would help the entire system. That is the one thing. And second thing is that sometimes in case of home buyers, you work as authorized representative. So as I said that a convention is there which guides the members of the COC. In case of home buyers also, it's basically a group where everybody has their own whims and fancies. See, my decision would be broadly guided by the resources I have, the timelines I have, my background and all. So for home buyers, also being a home buyer myself, I've seen a group where everybody is looking forward to have his ओन घर मेरा अपना घर मिल जाए मुझे दैट इज समथिंग बाकी चीजें होती रहेंगी तो दैट केस ऑल्सो द रोल ऑफ an IP becomes very important. You need to understand that you are not dealing with a homogeneous group. Basically, you are dealing with a heterogeneous group. So these are the two aspects which I wanted to bring to your notice. And these are the two aspects where laws, rules, codes, guidelines, and all may or may not help you. So, why I wanted to point out these two aspects is this is the platform which guides you through the experiences of an experienced IP that I have traveled this path, and these are the problems which I have faced while traveling the path. So, if you come across such problems, this could be one of the solutions. So, these are the things which you won't find it anywhere else. So, the technical session which is going to be there, Amit Gupta and Jigar Bhatt, I would request all of you to carefully listen to those because this is ultimately going to help you. The system which I have seen, if something goes wrong, is the IP which is held accountable, not the COC. So, the last but not least, I would also like to tell you that this being a relay race, because those who have already attained the knowledge, they are going to pass on the baton to you. So, just accept the baton and run your lap with full zeal and full of energy. Thank you.
Thank you so much, sir, for throwing some light upon the subject. And before now we begin further with the first session, I would like to request all the participants to please keep their mics on mute. And in case they have any query, they may share the same in the chat box or raise their hand so that the session is not disturbed. Thank you, sir. And now, without any further delay, I would like to invite Mr. Jigar Bhatt, sir. Sir is a national rank holder chartered accountant, having an experience of more than 15 years in BFSI sector. He's a founder of the firm JTB and Associates, a chartered accountancy firm specialized in audits, stress assets resolution, due diligence, violence, and transaction advisory, having team of insolvency professionals, experienced bankers, lawyers, and CAs. Sir holds expertise in stress assets resolution and IBC laws, also a member of ICAI and is a registered IP with IBBI. Sir has also been a guest faculty in various forums as well as in our institute. Sir, on the behalf of ICSI and IBBI, I welcome you for today's session. And now I would request you to please take over.
Yeah, thank you so much, Trashla, for such a warm introduction. Thank you so much. And yeah, I hope the screen is visible to all.
Yes, sir, it's visible.
So first of all, very warm good afternoon to all the participants and welcome to the workshop organized by ICSI IPA. And I would be facilitating you. I won't say I'm a speaker, I am just a facilitator because it's a workshop. So it would be great if we interact and if we share, exchange our views on the topic, right? So before we begin, I would like to take a moment to thank all of you for taking your time out and participating in this workshop. Yeah, apart from deadline of completing the CPE, I hope it would be a good interactive session wherein we all will learn as a group, right? And first of all, thank you so much, Deepak ji. He has set a very good tone for this workshop. Couple of things which he has reiterated with his experience. These are actually a fact. So when he said that committee members, they understand everything, but we need to present things in a way that they have to convince their approving authorities for taking the decisions. So that is a very important aspect. We have to convince them and we have to minutize whatever discussion that has been taken place, whatever logical things which we have discussed, that has to be minutized so that they can use the same for seeking authorities from their approving authorities. So that is one of the very important things that Deepak ji has pointed out. Thank you so much, sir. And yeah, let's begin. So I have tried to put the workshop in a perspective that we'll discuss some 8 to 9 points. We'll go by agenda as if it's a committee meeting, so that it will be in a better perspective and we'll have a good understanding as well as discussion. I also encourage all the participants to discuss, raise questions, so that we are here to learn from each other's experiences and understanding of the IBC as a whole. IBC being quite a new legislation, it is an evolving and we don't have a lot of precedents. So that is the reason all situations are different, all situations are unique. So the more we discuss, the more we come up with a situation, then it will be a good practical learning for all of us. So let's start to set the perspective how action starts. So basically, it starts with the pronouncement of order admitting corporate insolvency resolution process of a corporate debtor, right? So before we move to the topic of e-voting, we need to set a tone that before e-voting, what all procedures take place. So I believe all of us are aware, but let's just brief. So as soon as we receive the copy of the order, the action starts as an interim resolution professional. We have to thoroughly read the order, review it, and prepare a model CIRP timeline, because it's a time-bound process which is having utmost of importance. So we have to follow each and every timeline judicially. So as soon as we receive the order, we have to prepare a 180 days model timeline. And then we have to track what actions we are taking and where we are lacking. So we were studying PERT CPM principles when we were in 12th standard or probably in foundation. So it helps. So wherever we are lacking, see, some things are within our control and some things are not in our control. So whatever things are not in our control, we have to manage the timelines accordingly. So whatever there which is in our control, we should try to reduce. So if IBC regulations or a law says maximum period of 15 days, then try to do it within 10 days. So it will help you to overcome some of the decisions which are dependent upon the committee. So you can use that timeline to manage the overall show within 180 days. Then as soon as you receive the order, check the company master data of the corporate debtor and start documenting everything. Prepare a draft Form A, get it vetted, and then go ahead with the public announcement. So understand wherever corporate data is having offices, go through the master data, corporate data's website, other due diligence platform, and come up with whatever places which are available on record. Try to do public announcement in all the places, so that ultimately, after sometimes someone should not come to you as a claimant and say that they have not read the advertisement. Disclosure with IPA and IBBI. All of us are very versed with it. Then communicate with the suspended management for taking custody of the CIRP assets. It is very important. So you have to inform suspended management that you are basically an administrator. So he need to extend support to you. So be assertive, don't be aggressive, convince him that this is the process and he has to give you cooperation, because without cooperation of the suspended management, it would be very difficult to manage the CIRP. Though we do have option of initiating section 19 application and all, but it is all time consuming, and getting decision from the NCLT will take its own time. So always try to explain corporate data ex-management personnel that this is a process. If you cooperate, then it is ultimately good for everyone, and it is his company, and we are helping him to come out of the corporate insolvency resolution through this process. So that will, I believe any logical person would understand that. Then communicate with the creditors. So financial institutions, government authorities, industrial development corporation, power board, etc. Communicate with everyone that the company is into CIRP, the moratorium is applicable, and whosoever is any claim, then they should submit the claim and lodge the claims. So maximum you communicate, it would be easy for you at the later stage when your resolution plan is for approval. This communication would help. Very important aspect, taking custody and control of the corporate data. So try to get the understanding of all the assets through the balance sheet after discussion with the financial creditors, because they must have done a lot of documentation during extending the financial facilities, check the property papers, security charge, understand from the suspended management what all assets belong to the corporate debtor, and try to take the custody of all assets, so that if you have the custody of the asset, then you will be able to present the same in the information memorandum. Then ultimately you will be able to get the good value from the resolution applicants. So taking custody and control of the asset is of much importance. Analyze the books of account of the corporate debtor. Deeply study the books of account of the corporate debtor. So you have that 14 days timeline. So before you receive the claims, try to understand and analyze the company's books of accounts. So if you have access to the accounting system, then it will help. Try to analyze books of accounts for last 2 to 3 years. It will give a good perspective about the business operation of the corporate debtor. So against that Form A, you will receive certain claims. Verify it thoroughly. You have got 7 days to verify it thoroughly, because ultimately it's a constitution of committee of creditors would be from the claims you are admitting. This is one of the most important process, and a lot of litigation took place based on the verification of claim. So try to document entire procedure. So whatever steps you are taking for verifying the claims, document everything. And then comes the notice of first CoC meeting. So this is a 30 days process, a lot of things to do within 30 days, and then you reach at the first 30 days, you have to convene a first CoC meeting. So next, now let's move on the notice of committee of creditor meeting and broad agenda item which requires e-voting. If we bifurcate what all items needs to be discussed with the committee members and what items require approval from the committee members, there are 4 quadrants. So if you see left top, necessary and allowed. So whatever things which are necessary to perform as a duty of the IRP or RP and which are allowed within the provision of the code, this doesn't require any approval. You just need to inform it to the committee members during the committee meeting. There are certain things which are necessary but not explicitly allowed. All those items require approval from the committee members. Then you will find certain items which are not necessary but allowed within the code. For those items, if you are not taking any action, then inform members. If you are taking any action, then seek an approval from the committee. And items which are not necessary, not allowed, you don't need to perform, but do document it. Why? So it should not be that it is not a negligence or you have not forgotten anything to you have taken a deliberate decision that these items which are not necessary, that is the reason you are not taking any decisions in that area, but do document it. So the items which are necessary and not allowed required approval, items which are not necessary but allowed, those items are also required approval from the committee members. So before convening the meeting, you need to prepare and share documents related to the matters to be discussed with the committee members. So if you want to control the committee meeting quite positively and to come up with a good solution, then prepare a decent document list, give all documents to the committee member beforehand. So first meeting requires notice of 5 days. So try to share all the documents so that they would come after studying. Because in meeting, it is not possible for them to go through the documents. So if they don't go through the documents, they won't take decisions in the meeting and it would be ultimately delayed the procedure. So prepare a list of documents, all supporting everything you share with the committee members beforehand. Then circulate a notice of the meeting to the committee members. Be very clear with respect to all the agenda items which are to be discussed and which are to be voted upon. Then convene a CoC meeting. Discuss all the agenda items which are to be informed and which are to be voted upon in detail, logically, and try to explain with a logical reasoning why you are taking certain decisions or why you are proposing certain decisions. So after conclusion of the meeting and after proposing a voting, you have to circulate minutes of the meeting along with the agenda items put up for voting. So one of the agenda item would be to decide the methodology and manner of the voting. So manner of the voting could be through raise of hand, through voice, yes or no, through e-voting or ballot voting. But as Deepak ji said, usually whosoever members come to attend the meeting, they would be having certain authorities. However, within CIRP framework, certain delegation is not available with them. So they would require approval from their higher authorities. So usually committee members prefers a ballot voting or an e-voting. E-voting is a better because it tracks IP address, but it is having a trail. So that always try to go for e-voting. Sometimes committee member would say, rather than incurring cost on e-voting, you should go with the ballot voting. However, in CIRP scheme of things, especially considering the litigation aspect, you should always insist for the e-voting. So there are a couple of platforms available. Some platforms are quite expensive, rather some platforms are quite reasonable. So try to explore which suits your size of the company and accordingly choose a voting platform. Then after once voting is done, circulate the minutes of the meeting along with written record of the summary of the decisions taken on relevant agenda item along with the names of the member of the committee who voted for or against the decision or abstained from voting. This is one of the very important circular issued by IBBI in August 2018. So it says the committee members who are attending the meeting, they should have a proper authority to make decision on the spot without deferring decision for want of internal approval from financial creditors. So always try to reiterate. So during your notice, in your notice mention that whosoever is attending the meeting, the person must have the authority to decide on the agenda items. So if they don't have the authority, you educate them that you please request the person, authorized officer who is having authority to attend the meeting. Nowadays, we are doing meeting on online platform. So it's not very difficult for the higher authorities to attend the meeting. So always insist upon this circular, inform them, educate them, and always try to have a members in the committee meeting who are having the authority. It will save a lot of your time in decision making. So as a resolution professional, we are supposed to give notice of the meeting to members of the committee, including authorized representative, members of the suspended board. They are the invitees and they would be required whenever anything to discuss upon with respect to the corporate data. They don't have any voting right. Then the operational creditors or the representative, if the amount of their aggregate dues is not less than 10%. So these are the people who requires notice of the meeting. Then I have summarized a list of agenda items which would require voting during the meeting. So I'll just quickly go through those agendas which would require. So first of all, you need to vote upon the cost incurred till first CoC meeting as an interim resolution professional. Then the most important agenda item to vote upon and approve the appointment of IRP as a resolution professional and pass the resolution with or without modification. So this is the most important resolution, and you have to try that resolution should go through in the first meeting itself without any e-voting in the meeting itself. Then you need a voting on reduction of the notice period of the CoC meeting, because first meeting happens with a 5 working days notice, then you try to reduce it up to 2 days. To vote upon appointment of security agency. So if you have the custody and control of the asset, you must have deployed certain security guards. So try to get approval for ratification of cost as well as for regular monthly expenditure of the security guards. So these all items require voting from committee members explicitly, and you have to document it. Then you require voting upon the fixing the fees of the legal counsel to support the resolution profession during the CIRP process. So if matters are having a lot of litigation, then always try to have a counsel on a retainership basis rather than going on a per application basis to reduce on the cost part. Then take a voting on the upper limit of the fees of the registered valuers. See, as a IRP or RP, we don't require approval for appointing registered valuers. However, their fees has to be approved. So sometime what happens, IRP to RP replacement happens, and it takes some time, around 30 days time period in NCLT to get the order of the replacement. So now that 47-day limit would breach, so ultimately he would appoint the valuers. If the fees are not approved on a upper cap limit, then it would be ultimately a difficult task for the RP, because valuers must have started their work. Once they have received, now once they issue the report, RP would be there. Then CoC would say we have not approved the fees and all this stuff. So always try to get approval of the upper limit of the fees of the registered value. Then seek voting upon the authorizing RP to have a debit transaction in the account of the corporate debtor, so that he can have a smooth functioning during the CIRP, especially if the entity is a going concern. Then comes taking voting on the expression of interest form G, which you require to publish. So you have to decide upon the basic eligibility criteria. It has to be deliberated with the committee members, and always try to get a proper voting done on the parameters that you have fixed. Then to vote upon the upper limit of the transaction auditor. So if you feel that you need to appoint a transaction auditor, then try to get approval for the upper limit of the transaction auditor. Then in every committee meeting, I would always recommend that you should take approval of the incremental expenditure incurred from the last meeting till the meeting you are convening, so that it would be a easy documentation for the CIRP cost. Then take the voting on the request for resolution plan document and evaluation matrix. If you required to conduct a 29A due diligence after the resolution plan, then take approval of the cost, because sometimes you need to explore artificial intelligence AI platform which charge somewhere in the range of 25,000 to 50,000, depends upon the connections. So try to get an approval, because ultimately 29A due diligence is your responsibility as an RP. So take a cost approval, have a good thorough due diligence through AI platforms, and have a report along with your compliance form edge. Then if your process is not getting completed within 180 days, then discuss it with the committee members and seek their opinion on extension of the timeline, because as per section 12.2, the committee can decide to extend the CIRP timeline and not the RP. To always have a voting on this particular aspect. Then if you are modifying your RFRP document during the course of action, then also take approval of a modified RFRP. You can also take approval on the distribution pattern within the resolution plan. So resolution applicant is supposed to offer a payment to a class of creditors. However, internal distribution amongst the class of creditors is to be decided considering the security interest. So sometimes security interest is not known to the resolution applicants. So always keep it open for the committee members to decide upon the internal distribution so that there won't be any issues at a subsequent stage. Then to vote upon the approval of the resolution plan submitted by so and so resolution applicant. If any additional reliefs which are sought in the resolution plan, which committee members feels that they want to separately vote upon, then always keep it as a separate voting agenda item. Then this is also very important to vote upon the performance linked incentive fees, which is recently proposed as per regulation 34B4. So this is to be voted upon by the committee members because it is discretionary. So if you have done your work diligently within time frame, and if members are satisfied with your work, then you can always propose for a performance linked incentive. There are two incentives. One is within completion of CIRP within time frame, and another is for value maximization. So this would require a voting. And if your resolution plan is going for a voting, always have a resolution with respect to the liquidation, because if adjudicating authority decide against the resolution plan which has been approved by the committee, then it would trigger for the liquidation. So always have a resolution passed in the last CoC meeting with respect to regulation 39B, 39BA, C, D, etc. And vote upon the fees of the liquidator. So I believe broadly I have tried to cover what all agenda items which would require voting from the committee members. I hope all we are in sync.
Yes, sir.
Shall I move ahead? Yeah, thank you. So let's move to next section, that is voting by the committee and voting through electronic means. So as we are aware, these three regulations from IBBI, Insolvency Resolution Process for Corporate Person Regulation 2016. So Regulation 25, voting by the committee, Regulation 25A, voting by authorized representative, and Regulation 26, voting through electronic means. So these three regulations are required to be thoroughly understood because it governs the entire voting exercise and e-voting means and what are all duties of the IRP as an administrator of the process. So I won't read the provisions. I believe everyone understands and everyone is aware of the provisions. So Regulation 25 is voting by the committee. So it says all the agenda item which required voting, it has to be put up before the committee and they will take the decisions. So in 66 is the threshold limit for almost all the resolutions. So you would require 66% voting in favor of your resolution. It also says the members who doesn't exercise the voting during the meeting, then they should be given an option to e-vote. Then accordingly, you have to set up an e-voting, then you have to circulate the e-voting links, etc., the procedure, and then they will vote. So voting by authorized representative. So if any authorized representatives are there, especially in home buyer matter, then they will exercise voting in a separate way. So first, the authorized representative will take voting from his group, then ultimately he will exercise the voting on behalf of the group. And Regulation 20, this Regulation 26 is voting through electronic means. So it says electronic voting system means a secure system based on the process of display of electronic ballot, recording of votes, the members of the committee. So ultimately around 10 to 12 players are there which are providing a good e-voting system. So we can exercise and explore based on the cost-effective solutions and kind of number of voters that we do have. So accordingly, we can select the e-voting platform. And after conducting the voting, we are supposed at the conclusion of the voting, we have to circulate the record within 24 hours to the committee members, disclosing them what is the outcome of the e-voting exercise. So these are the couple of items as per section 28, which required approval of the committee on certain transactions. So it goes like, if you want to raise an interim finance, then it requires explicit approval from the committee. If you want to create any security interest over the assets of the corporate debtor, then it requires a specific approval from the committee. If you want to change the capital structure, if you want to change the ownership interest, if you are entering into any debit transaction which is in excess of what amount you have taken in the first meeting, then you require a specific approval from the committee. So all these decisions, if you are taking, then it requires a pre-approval from the committee. Any related party transactions, if you want to amend the constitutional document, if you wish to delegate authority to any other person regarding disposal of shares, if you want to make any change in the management of the corporate debtor or its subsidiary, transferring rights or financial dates of the operational date. So any such transaction, section 28 is very clear. All this transaction, if you are taking place, then it requires a pre-approval from the committee members. So any change in appointment and terms of the contract of statutory auditors or internal auditors. So along with the agenda items which are general in nature, I have discussed previously, these are very specific, case specific. If you are taking any decision, and it requires pre-approval. This is the procedure for seeking approval from the committee. So where any action is taken by the resolution professional without seeking the approval of the committee of the creditors in a manner as required in this section, such actions shall be void, and the committee of creditors may report the action of the resolution professional to the board for taking necessary action against him under this code if she doesn't follow the above process. So that is the reason you have to be very clear with minutizing all your actions and put whatever actions which require explicit approval, or if you feel that it is not provided in the law but you are taking certain decisions, then always document the decision of the committee through voting, and preferably through e-voting. So now coming to a specific agenda of this workshop, how to conduct an e-voting. So I have set a background, what all agenda items required voting, why it is required, why it is essential. Now let's have a look at how to conduct an e-voting. So in the Companies Act, obviously it is an ICSI, IPA. So I believe most of the members are company secretaries. So they are well versed with the exercise that is taking place within the Companies Act. So in compliance to section 108, 110, and all, this is a basic which in before all AGMs, all the companies are sharing. So this is how they take the e-voting from the shareholders. IBC e-voting is a different than this voting exercise, because here it is a committee members which are on a not spread across, plus you are discussing one-on-one with them during the meeting and then you are seeking the vote. Here these are the shareholders. So that is a different process under the SEBI regulations and all. Usually NSDL platform is being used by the companies. And with the voting, they also give a procedure how to exercise your voting. So I believe all the members are well versed with this voting exercise. But to make it simple, how to set up an e-voting as a resolution profession. Now I will take you through that process. So here I have tried to jot down some of the screenshot from the system itself, so it would be easy for you to understand how to set up an e-voting. So this is one of the platform which is quite reasonable and it is having a security. I don't promote anything, so I won't name the platform. So ultimately you have to create your login with respect to that particular company of which you are a resolution professional, right? So this is the first page. You have to sign up, you have to create your login for that specific CIRP process. Once you have a login, that you will come up on this page. Every time you have to log in with your registered email ID, usually it would be a CIRP email ID which you create for the conducting the entire process. Once you log in, it will give you this kind of a page wherein you have to decide what kind of event you want to host. So ultimately it would be I'll come to that page. So here you have to mention what is the event. So it's a first CoC meeting, second CoC meeting, any special meeting, any special request, anything. So you have to create an event. So be very clear with respect to whatever you are sharing, because ultimately it is a permanent record and it will go to the NCLT. So whenever you are set up an e-voting, you should be very clear, grammatically very clear with respect to your sentences, with respect to the name of the event, the description of the event and everything. So try to disclose everything on this platform. Then choose a plan. So here, usually it's a motion voting. So you have to select a motion voting through email or SMS. Then it will give you a page wherein you are supposed to upload all the agenda items. So one by one, you have to upload all the agenda items. So you must have your minutes of the meeting prepared. So copy paste all the agenda item one by one on this screen. So after incorporating agenda item, it will ask you what kind of choice you want to give. So usually there would be three choice: voting in favor, against, or abstain from voting. So you have to give these three choice to your committee for voting. It would look like this. So I believe I have, yeah. So it would look like this is the preview of the ballot paper. So it will have the resolution item and it will have a three options: approved, not approved, or abstain. So after reviewing, you can, after reviewing, you have to add the list of the members. So if you have a large set of members, then you should prepare an Excel file. They will allow you to download a blank file and you have to upload the list of the members in that file and then you can upload. If you have a lesser number of members, probably 3, 4, 5 members, then you can add it manually as well. So after setting all the agenda items, you have to add list of the members. It would require a serial number, member specific ID, first name, last name, and their email ID and mobile number. And then you have to assign the weightage. So weightage would be in reference to their claim admission ratio. So once you add, it will show you what all members you have added and it will look like this. So I have just for one example, I have uploaded ab.com, weight 100%. So single voter, it would look like this. Then it will take you to the payment gateway. So if you are a regular member, then they will allow you for a monthly billing. But if you are doing it on an ad hoc basis, then you have to make a upfront payment. So usually this secured voting platform charges anything in between 2,500 to 10,000 rupees for hosting a voting. Then you have to set the voting timelines. So voting timelines would be decided during the meeting itself. So when you conduct a meeting, whenever committee members propose you to have a e-voting, then decide the voting timeline. So after circulation of the minutes of the meeting, which is within 48 hours of conclusion of the meeting, be very specific with respect to the voting timeline. So be categorically clear that you will open voting timeline on so-and-so time, so-and-so date, and it will end on so-and-so time, so-and-so date. So whatever you have decided in the committee meeting, you have to fix timeline accordingly. And ultimately, once your voting is live, all the committee members whose email IDs are provided in the list, they will get an email that this voting is available. And if you have set a one-time password kind of a formula on mobile and all, this process would be there. They have to click on the link. Then they will get a OTP on their registered email ID as well as the mobile number. And then they'll able to see the ballot paper and then they can exercise their voting. So below you can see monitor voting progress. So as a resolution professional, as the one who has set up the voting, he will be able to overview what is the progress of the voting. You won't be able to see what are the who has voted in favor, against, abstain. You won't be able to see until you close the voting timelines. But you will be able to monitor whosoever has voted and who has not voted. You will have an option to send the reminders as well. The system usually give you 3 to 5 free reminders. You just have to log into the system and click so that all the members will get an email with respect to the reminder from the system itself. Any question, anything to discuss till this moment? Or shall I proceed?
So what are 3-4 common platforms which are being used by RP? Let us. We are not talking about your promoting or branding, but at least everyone should know.
So from my
Cisco,
personal
experience, I have used one Cisco.
Cisco is quite expensive. Yes.
Yeah. Okay.
So the one I usually use is secured voting, which is quite reasonable, and they charge 2,500 flat. Then there is a right to vote. They are charging some 4,500 per voting. Then even NSDL platform is also available, but it's quite expensive. So usually I prefer secured voting or right to vote, which are easy to set up. You don't require any intervention with the platform itself. So you or your team can set up the e-voting and they can monitor the show. So it is very easy to use interface. So
What is the
these
name,
are
sir? What you have told the name?
secured voting
Secured voting.
and right to vote.
Okay. Thank you, sir.
So it was on how to conduct an e-voting. Now let's move on how to conclude an e-voting, because concluding an e-voting itself is one of the important event, and especially certain agenda items like approval of the resolution plan. So if you reach at the conclusion state, then it's an achievement, because what happens, committee members are dependent upon the higher authorities and sometimes depends upon the haircut. The proposal goes up to the committee level. So committee seats once a week kind of a thing. And if your proposal don't go within that committee meeting, then they will always give you request for extending the e-votings. So if you reach at this conclusion of e-voting, then it's an achievement. So as I said, you can progress, you can monitor the progress of the voting. So here I have taken a screenshot from one live voting event. It is showing that overall progress 50%. So out of two members have voted, 2 have not voted. And voting timeline is ending in 2 days, 1 hour, 57 minutes, 38 seconds, right? So this is how you can progress. From here only, you can send the reminders to all the members who have not voted, right? So this is the monitoring window of the voting platform. Once you conclude the voting, it will show you whosoever has voted in favor, against. So it will give you some graphical presentation. And this is the most important sheet which you are supposed to keep even with whatever application you are filing before the adjudicating authority. It is showing who has voted, when they have voted, what time, and which was the IP through which they have voted. So this is the most important sheet which a platform will give you. You have to download it from, once you conclude the voting event, they will allow you to download entire ballot papers with the voting of all the members, and it will give you a timeline when members voted. So you have to produce it along with your application, because whenever any application goes to NCLT with respect to, say, for example, replacement of IRP, or say extension of timeline or upload of resolution plan, the adjudicating authority always asks for the, where is the voting, where is the resolution, and where is the voting. So always attach this sheet along with your application. And as I said, after conclusion of the voting, you are supposed to circulate the outcome. So this is just a summary of one of the resolution. So you have to produce what was the voting share, who voted in favor, who voted against, and who all remain abstained. So this is how you have to circulate. This is one of the format which I use. I just try to produce before the attendees. So this is how you have to conclude the voting, and then you have to circulate the minutes of the meeting, revised one, along with the voting result, as well as the written record of the voting outcome. Yes. So now I think now this point would require a good deliberation and discussion among the participants. Interpretation of e-voting results, right? So I believe, see, I am not a lawyer. So I am insolvency professional. I believe as an insolvency professional, you have to be practical, and you are basically an entrepreneur. So I may be wrong on my interpretation part, but so that we can deliberate and how to decide and how to interpret the voting result. So my questions to the group is that if the member remain abstain from voting, whether should we count his vote or not? Members, what are your views? So let's take an example or situation. So assuming that the total number of voting shares based on financial debt availed by the corporate debtor is ₹100. And at a meeting of the creditor, financial creditors holding 20 rupees debt has remained abstain. So technically 80% people have voted, right? So out of 80, 70 has voted in favor and 10 has voted against the resolution. Fine. So out of 100, 70 has voted in favor, 10 has voted against, and 20 has remained abstain. So now I want to calculate 75%. See, I'm keeping 75%, not 66, because it would be easy to calculate. So how to calculate this 75%? If I calculate out of 100, 70 is voted in favor, then it is a 70% threshold I am achieving. So I am unable to pass the resolution if it requires majority of 75. But if I interpret that I am supposed to see only those who have explicitly exercised their vote, whether in favor or against, then in that scheme of thing, 80% have exercised, out of which 70 is voted in favor. So technically it is crossing the threshold of 75%. So what is the view of other members? How would you interpret this result?
You have to take into account votes, abstained votes also, and calculate as negative voting.
So you mean to say whosoever remain abstain from voting, it should be considered as a negatively voted?
Yes.
Okay. And
out of 80, you have to.
So another view is like out of 80. So 20, since they have not exercised their right, we should not consider their right.
Yeah.
Technically, there are only two views possible, but we don't have a polling option in Zoom. So I won't be able to see what is the view of the group as a whole, but obviously there are two options. So what does majority believes? Well, how to interpret the abstain?
Sir, we can give our opinion on chat.
Please, sir, give your opinion on chat. Let's consider 10 first 10 responses. So the question is, the members who remain abstain from voting.
Sir.
Yes, sir.
Sir, good afternoon, sir. Am I audible?
Yeah, absolutely, sir.
Sir, the members physically or virtually present during the voting session shall be taken into consideration, irrespective of the fact whether the member abstains from voting or not.
So if I remain present in the meeting, right? But when you put up an agenda item for voting, I said I would require internal approval. So please set it for e-voting, right? And after setting e-voting, and I don't exercise my vote. So I had remained present, but I did not vote.
So your physical presence or virtual presence is taken into consideration, sir. So 100.
But I have not voted. No, it is not in favor, not in against. I have remained abstain.
That's why abstention should be taken as a negative voting.
So okay, fine. That is one view. That whosoever remain abstain, it would be considered as a negatively voted. This is actually practically this is very important aspect, because you will come across a lot of situations wherein at arriving at a 66% threshold, you have to interpret what to decide upon the people who have not voted. And as much as I understand, there are no settled ruling on this as well. So we are getting mixed views. So let's deliberate this in little bit more detail. So I'll just say the process of decision making at the CoC. The process of decision making at a CoC is very often involves existential questions. The very survival of the corporate data depend upon whether the CoC has decided to pass the resolution plan or fail to do so. Hence, the question become critical. Can a member who decides not to vote at all and therefore have no views on the matter whatsoever, may be counted at par with a person who has explicitly expressed the negative view? So someone is explicitly expressing a negative view and one is not sharing any view. So can we consider both at par? That is the question, right? So probably these are 4 to 5 principles, or I would say the precedents that we should consider before arriving at a conclusion that how to interpret a member who has abstained from decision making in calculating overall voting ratio. So one would be the general rationale of collective decision making. Then law of meetings as settled over decades of authorities and rulings. Then notes of the BLRC, very important. Then amendments to CIRP regulations and the decision or indecision which are available from NCLT ruling. So general rationale of collective decision making is that whosoever explicitly express their views, either positive or negative, that should be given a weightage rather than the people who are not expressing any views. Because ultimately you require a super majority. 66% is kind of a super majority. So who majority favor or against? If I don't make any decision, then how if I consider it as a negative decision, if I want to give a negative view, then I should have voted. No, I am not exercising my voting right. But still, so so general rationale says that whosoever explicitly express their views, only their views should be considered. Second is general law of voting. So over several years, the general law of voting expressed that whosoever expressed their views, it should be considered. So I'll just read. There can also be members who do not express their views at all, either by not attending the meeting or by attending the meeting, but voting, not voting or abstaining from the voting. So you are attending the meeting and now you are not voting, then ultimately if I take you as a negative, then you should have exercised your view, no? So to count the votes and to arrive at the conclusion on whether or not an agenda is resolved at the meeting, the votes in favor and the votes against are weighted and the majority is counted by finding the proportion of the votes cast in favor of the votes cast against. In no circumstances, the invalid votes or votes not casted at all are to be counted to calculate the majority. So this is the conclusion from the general law of voting. So there are several judgments on the general law of voting. If you Google or if you see in some legal repository, you will come across there are certain rulings from High Court as well. Now voting in context of IBC. So in IBC, you have a, so as we are aware that commercial wisdom of the committee of creditor is of utmost importance. It is a supreme, right? So the committee members are having certain rights and certain duties. So ultimately, if I'm attending the committee meetings and I am responsible for the fate of the corporate debtor, and if I don't exercise my right either to vote or in favor or against, then ultimately I am not doing my duties, what all duties are bestowed upon me through the law. So voting in context of the IBC, as we believe that you have to exercise your right. So voting share is a different thing and voting right is a different thing. You are getting voting share through your claims, right? So if I am lodging my claim and it is been vouched and verified by the IRP or RP, and if he is admitting my claim, then I have a right to vote in the committee meeting. So voting share is there, but right would come when I exercise my right. So I do have a voting share, but I am not exercising, then I don't have a right. These are some of the synopsis from the BLRC report, wherein if a creditor chooses not to participate in the negotiation, despite having so informed, the vote of creditor committee will be calculated without the vote of that particular creditor. This has been documented in the BLRC report itself. The final arrangement has to have a majority vote of creditors. Creditors abstained at the meeting will have to accept the decision of those present. So if I don't remain present, then I have to accept the decision of the members who were present in the meeting and ultimately voted. Then I have come across one ruling from, I believe, NCLT Kolkata. It was Hyderabad. It was NCLT Hyderabad, in which it says IBC did not say whether such percentage is out of the total voting share of the financial creditor or those present during the meeting of respective CoC. So it was not a decision. It was a confusing that IBC is not clear. So since IBC is not clear, you have to see the general provisions, general rule of law, general rule of meeting, and then you have to arrive at the conclusion. how to calculate the voting outcome. So as I said, voting right vis-a-vis voting share. You are getting voting share through your claim, but voting right only when you exercise your right. Now, dissenting financial creditor, this term is used only once in regulation 38(1)(c), which says the dissenting financial creditor should be paid in priority over assenting financial creditor in the distribution of the resolution plan amount. So in this particular provisions, lawmaker had clarified, if I abstain from voting, then I would be constituted as a dissenting financial creditor. But that dissenting financial credit term is used only once. So if the intent of the regulator is to interpret, if I remain abstain, then I would be considered as voted against, then they would have mentioned dissenting financial creditor terms everywhere. But this term is used only once. That is regarding the approval of the resolution plan and distribution of the proceeds of the plan. So after going through all these principles and this specific provision which has been used only once, the conclusion is that the people who don't vote, their vote won't be considered either in positive or negative. So the ratio would be arrived from the people who have voted in favor or against. That is the interpretation I am following since last 3-4 years of experience in IBC framework, and probably it has not been challenged. So we can discuss now. Now members, tell me, do you have any different opinion? Then we can consider that and we can evolve on what to do if we come across such situations.
Ultimately, it is the total voting share which prevails, not the persons who have attended the voting. So it is as good as taking them as negative vote on abstention financial creditors.
No, sir. See, dissenting financial creditor terms is only used once. That is specifically in regulation number 38.
No,
So,
so
why, see, why, if I want to vote negatively, then I should exercise my vote, no?
No, see, exercising.
Whosoever is not exercising, ultimately, see, in our example, if 80% people are exercising their vote, okay, some in favor, some against, and 20 are not exercising, then ultimately I am going by the majority. I am giving my right to the people who are voting. So whosoever is voting, it my 20% would be distributed among positive and negative appropriately.
Sir, for considering the voting share, it is not mentioned that those who are present only, their share only should be considered. For passing a 66% resolution, you cannot say that those who are present, their share only should be taken as 66%. Nothing, nowhere it is mentioned. So that's why if you take the total percentage of votes and determining the voting share, then automatically it becomes a negative vote.
No, but they are not exercising their right. So how would I interpret that they have voted negatively? There is a possibility due to some technical issues or not getting approval. Why? See, ultimately in the committee we are discussing a lot of important agenda items that through proper notice. All right. So notice was served, meeting was convened, the items were discussed, and now based on your request, you are not voted in the meeting. So you refer to the circular of 2018 IBBI. The committee members are supposed to decide things in the meeting itself. Now we are facilitating you by giving an e-voting option. Still, you are not exercising your right. Then I can't take it as you are voting negatively, because you are given ample of opportunity to discuss. Then you have to vote negatively. Now, if you want to vote negatively, you vote negatively. You can't remain abstain and say that I am voting negatively.
Sir, you are only interpreting what nowhere it is mentioned that.
So, sir, what will you do? You will come up with another CoC meeting if your resolution doesn't go through.
In the same
30%,
way,
40%.
In the same way, the person who is not abstained from voting, he can also is not voting. No, you are saying that he has to go by majority. Same way applies the other way also.
No, I am not clear. What is your view? How to interpret?
Nowhere it is mentioned that the votes of the persons who have attended or voted, their share only should be taken for deciding the voting.
Let's read the provisions, sir. So regulation 3025. Resolution professionals shall take a vote of the members of the committee present in the meeting on any item listed for voting after discussion on the same. So technically, I am not supposed to share voting, e-voting link to the people who have not remained present in the meeting, right? I am not supposed to invite them for voting because you have not participated in the meeting. Then you are losing your right. You do have a share, but you are losing your right to vote. So first of all, if someone is not attending the meeting, then he is not having any right to vote. All right. So if I take a reference of this provision, the provision is very clear. You are given lot of supreme authority, then you have to exercise your right. So if you don't attend the meeting, you are losing your right. Similarly, if you don't exercise your voting, you are again losing your right. So it cannot be considered as a negative voting. That is my personal professional view. Now it is up to all of you to decide, because if you read the provision, it is clear whosoever attend the meeting, they only have a right to vote. So if someone is not attending the meeting or someone attending the meeting and not exercising the voting, then he is losing his right. Otherwise, what would happen? Again, you will convene a meeting. Again, those people won't vote. So it would be a paradox. How would you conclude within 180 days? Can we move ahead, or shall we still deliberate on this point?
Move ahead, sir.
Shall...
Go ahead, sir.
Yeah, thank you. Important aspects to which IRP, RP must give importance. So do you see, I believe voting is now very clear. What all agenda items to be voted, how to discuss, how to set up an e-voting, how to conclude an e-voting, and how to interpret the results. So probably interpretation of result is not having any conclusion because there are no settled principles. But a couple of judgments with respect to the law of meeting, etc., it has been interpreted that whosoever exercise their voting, their share only to be decided while declaring the result. So here I have just summarized all important aspects as an IRP, RP must give importance to the documentation of all the actions. So whatever actions you take, you have to document. And e-voting is one of the most important document whenever any matters are getting contested at court. So documentation is the key, and e-voting results are of a lot of importance. First 30 days of the process are very, very important, along with no surety on remuneration. So now certain guidelines have come in the picture that minimum fees criteria are there. So now that won't be a very difficult task. The problem would be, as an IRP, committee will fix your fees that, okay, they are replacing IRP, they will say, okay, fine, we are going to give you a remuneration of so and so amount. But if it takes a month or a month and a half to come up with a decision from NCLT regarding confirming appointment of the RP, as an IRP, you have to perform your duties. Now, performing duties for that time period, again, because committee will say, we have fixed the fees of the IRP period. I have seen process documents and internal documents of some of the banks. They have clear-cut guidance with respect to the fees of IRP and RP. So even if IRP is working for, say, 70 days, they will say fees of the IRP are fixed. So 30 days are very important. You have to demonstrate, if you work within the provision of the code, logically you explain everything to the committee, then probably there are a fair chances that committee will continue you as a RP, because if they go ahead with the replacement, it will take another 30-45 days of time. And again, RP would come, he will understand the corporate data, it will take another 15-20 days time. So it is in the interest of the overall stakeholders, all the stakeholders, that whosoever is appointed as an IRP, he should continue as an RP. But for that, you have to demonstrate that you are the perfect person to conduct this process. Then preparation of information memorandum, process document, request for resolution plan, evaluation matrix, these all are very critical, and you should consider all situations, all subject. See, if you want to eliminate the subjectivity from the process, then your RFRP document should be robust, which should cover everything. So give a clear-cut guideline to the PRAs so that there should not be any ambiguity with respect to the resolution plan. So your RFRP document should be the robust document which should cover all the situations, and there should not be any subjectivity left to the PRAs to decide upon. Notices of the committee of creditors, you have to be very smart with respect to drafting of the notice. You should not miss on any important agenda or any procedural aspects, because whenever things are getting contested, it will start from the notice of the meeting itself. Meeting of the committee of creditors, go well prepared. Though meeting will take only an hour or 2 hours probably to convene a meeting. However, be prepared. Devote enough time for preparing the committee meeting, because ultimately it's that 1 to 2 hours time in which you are supposed to explain everything to the committee member, make them understand, and they should be convinced with respect to your decisions, all decisions and all your strategies. So go well prepared for the meeting. Have a proper voting on all the agenda items. So we have discussed it at length, how to conduct an e-voting and how to interpret result and how to circulate. Then minutes of the meeting of the committee creditors with a record summary of the decisions taken. So be very sharp with respect to drafting. Don't use any jargons or any fancy English. Use simple English. Message should be very clear, because whenever things are going to NCLT for interpretation, your minutes of the meeting would be the base document. Ultimately, any application which advocate prepares, it is based on the minutes of the meeting itself. So devote a proper time. Don't left it to your team to draft the meeting. Always spend a good amount of time in drafting the minutes on your own, or at least review it thoroughly. Then representation before adjudicating authorities. Usually we do take services from the councils for representation of the matters. However, some items, especially with respect to the approval of the resolution plan. So my personal experience during last 12 months, I have got approval of the 2 resolution plan. And as an RP, I only represented matter before the adjudicating authorities. Because what happens, councils, see, court process is a different process altogether. And they'll go reading some of the aspects, and they know that in this hearing there won't be much of discussions, so they don't go prepared. They send their juniors and all. But whenever adjudicating authority take up the matter, they ask a lot of questions with respect to the resolution plan. So as an RP, since you have done the due diligence of the resolution plan, you are well versed with the resolution plan which has been approved by the committee. So always try to be there in person, maybe along with your counsel, so that any query which is being raised by the authority it can be solved then and there. Because the kind of a backlog of cases the NCLT is having, if you don't have an answer to one query, you will get an adjournment, and your matter will be listed after 30 days or 60 days. So in a 180 days process, if you are getting even a one adjournment, it is actually costing you, and not you, everyone, all the stakeholders are suffering. So if you calculate, if you quantify it, if your resolution plan amount is of 50 crore, and if 30 days deferment is because of your inability to resolve the query of the authorities, then it costs a lot to overall system. Maintain independence, objectivity, transparency, and accuracy throughout the process. Adherence to the timeline, very important, both professionally as well as now even the remuneration is there. If you complete your process within the 270 days timeline, then you are eligible for a performance linked incentive. So always adhere to the timelines. Focus on the resolution of the corporate data. This should be the mantra. We have to bring the resolution of the corporate data, because this is the true spirit of the code, and you are the administrator, you are the in charge, you are the driver of that particular assignment. So always focus on the resolution. Try to approach as many people as possible. Whenever you come up with a form G, don't just wait that someone will approach. See, nobody is going to approach. As a resolution professional, we are in this field. Still, how many form G we are reading in the newspaper, right? So ultimately, try to have a brief teaser of the corporate data, and then try to circulate it within your group, especially with the region. If your corporate data is in X region, and try to focus on the people who are having connect in those region, and try to circulate it to as many people as possible. Maintenance of record, very important. All the record have to be categorically and day wise you have to maintain, because whenever we received a notice of inspection notice from IBBI, they are asking for 100 documents. So if you are clear with your documentation, then for you it would be a very easy task to give all the documents at one go, and ultimately you will be able to come up with a clean sheet from the IBBI. And informed decision making. Whatever decisions you are taking, it should be informed, duly deliberated, discussed in the meeting of the committee of creditors, and properly voted upon. So if you have done a proper informed decision making, then nobody can question you. Now I am done with whatever I have jotted upon. Now I can keep the meeting or this workshop open for any discussion. So any queries, questions, suggestion, feedback, we can deliberate.
Sir, regarding the voting share and voting rights, can you just go to 34 of the Act, section 30, subsection 4 of the Act?
Section 30, subsection 4.
Yeah.
I am aware it is for resolution plan, no distribution of the proceeds.
No, you just go and see. Can you just display it, or how it is? Is it possible?
It is possible. I need to screen share. I'll what is the logic behind it? I can reproduce it before this platform.
It says the committee of creditors may approve a resolution plan by a vote of not less than 66% of voting share of financial creditors. It doesn't say whoever is present in the meeting. When you are approving a resolution plan, it should be approved by a 66% of the voting share of the financial creditors.
Correct. Go ahead. Only that line?
Yeah, that line. That implies that you have to take the entire voting share, whether they voted against or for.
See, I believe I produce one. No, whosoever attend the meeting, they only have a voting right.
No. See,
absolutely, sir.
If
I don't attend the meeting, how would I vote?
The approval of the resolution plan cannot be based on your attendance. It has to be 66% of the entire financial creditor share.
Voting share, it is voting share.
Yes.
66% voting share.
Yeah.
Those who have not voted.
No, it is not present. It is the entire financial creditors voting share.
Yes. Voting share. It should be voting share. It should be voting share. I think you are correct. It should be voting share.
So what about the dissenting financial creditors, sir? Even there is a regulation. Sir, regulation 30. Sir, regarding dissenting financial creditors, so it is a clear interpretation that dissenting financial creditors includes who are not voting.
When it is said that if it is the entire financial creditors voting share, if you take only the voting share of members who are present and take based on that, if you arrive at 66%, that is not valid.
Yeah, it is absolutely. It is a matter of interpretation. There are no settled principles. That is what I am telling. What will you do? Shall I suppose you have a situation wherein 50% people are voting and 50% are not voting. What will you do?
Yeah, then it is not passed.
No. What will you do?
Sir, unless it is 66%, it has not passed.
Then what would be this? So it is the 50% who have voted, they have categorically voted in favor. So you are basically the people who are not voting, they are superseding the people who have explicitly made a decision.
Sir, it has to be easy. The law says it has to be The share should be arrived based on the entire financial status, not on the persons who are present in the meeting.
Sir, it is voting share, not financial share. It is voting share only.
Financial creditor, sir.
Yes, yes. If out of 10, only 5 are present, then 5 would be 100%.
So basically, no, I am agree with both the views. And frankly speaking, whenever there are agenda items which are like approval of the resolution plan or liquidation of the corporate debtor, always try to have a 66% majority in overall. If you want to avoid all such objections or questions. See,
what is
I am completely...
Sir, what is the rationale for fixing 75% or 66%? It is basically to get
super majority, no? Sir, rational is a super majority. But if someone who has been given authority to act as a committee member, if he doesn't vote, then basically they should be penalized. Their right should not be considered.
Sir, out of 10 members, if only one person attends the meeting,
then there won't be a quorum, sir. Quorum.
No,
quorum 33%.
Suppose if 4 members attend out of 10, do you mean to say it is passed by 100%?
Absolutely, sir. Absolutely. What, as an RP, what will you do? You will come again, adjourn the meeting. What will you do? See, ultimately, if 33% majority is not there, then you have to adjourn the meeting on the next date. Okay, fine. Then you can convene the meeting. But if you are unable to pass the resolution, what would be the course of action? Again, you have to call for a meeting. Again, those people won't come.
But only if on next day only 25% are
then it's a quorum. Then it's a quorum.
Then it is a quorum. It will be
then
passed.
It's a quorum. Absolutely.
Yes.
See,
and it will be passed.
Otherwise,
and those will be considered 100%.
If I am lodging my claim, then I am a responsible person as a committee member. Then I have to attend the meeting and I have to participate in the decision making. If I don't, then I would be considered out of the committee for that particular voting item. So ultimately, you have to see, technically, as an RP, I always try to ensure, and I always ensure that 66% threshold should cover, out of 166% should reach. But sometimes you will face a situation, especially when there are no financial creditors. If there are no FCs, only OCs are there, then it would be very difficult to conduct the process. Otherwise, FCs would come in the meeting and they would also exercise. See, at most, they will ask for some extension. Usually, they will always exercise their voting. So, always try to ensure that you should achieve a threshold. But a situation wherein, despite of your attempt, you are not getting a threshold, then this should be the interpretation. That is my view. Ultimately, it left with the resolution professional, or even, see, ultimately, if nothing is there, then you can always approach adjudicating authority. They will again direct you to convene another CoC meeting. But within 180 days, it is not possible to convene meeting back to back for single resolution item. So fairly discussed, probably now we'll be able to take a good informed decision making on interpretation of the voting items. So any other query with respect to e-voting or anything on IBC? We can discuss. I think, yeah, Trashla, are you there?
Yes, sir. Yes, sir.
We do.
May I say something, sir?
Yes, sir. Yes, sir.
Yeah, please, sir.
Sir, what I feel that if the 50% voting is only there and the 180 days are being expired, then the best course of action with the RP shall be to go for the liquidation, giving all the facts of the matter that the voting took place wherein only 50% voting was made, that too in favor, and then the adjudicating authority may give the suitable directions.
Yes, sir, that can be done, but ultimately you have to convene another meeting, because see, law is whatever is there is a minimum. Ultimately, based on that platform, logically within the spirit of the law, you have to take certain decisions, right? So even if you go to adjudicating authority, they will direct a committee to have another meeting and vote. That would be the direction, but it will take a 2 months time.
In that case, extension shall be granted by the AA.
extension would be granted. No, it's no big deal. See, getting extension of 90 days is no big deal. If you have some logical reason, they will give you extension. But the thing is that you have to make an effort. You have to make efforts to bring all the committee members on board, then they have to vote. So why I said so during that e-voting access, that e-voting platform, I told you, no, we are having an option to send reminders. So be diligent. Send reminders daily. Make a good telephone calls to them. So get the voting done, either in favor or in against. So it is RP's duty. What happens? Some RPs, they just set up the e-voting and they don't follow. See, as a banker are handling 10 to 12 assignments. One team is handling 10 to 12 assignments. So sometimes they don't able to give priorities. Plus there are a lot of PCs and everything. So you have to be behind the bankers, behind the committee members, so that they can exercise the voting. So ultimately,
Thank you, sir.
if you don't do follow-up, then you would be in soup. Na? You would be approaching authorities and you are representing matters. So always try to get the 66% voting either in favor or against done.
It is must, correct.
So it is not written in law that we are supposed to do follow-up, but we must do
Can I come in? Can I come in,
Yes,
sir?
yes.
My name is Ramesh.
Yes, Ramesh ji.
Yeah, I've been following the conversation. My own opinion with regard to voting is that if you treat abstention as negative vote, it will cause a direct prejudice to people who have voted positively and negatively, number one. Number two, it will delay the resolution process, which goes against the spirit of IBC. So I think as a prudent RP, I would proceed with ignoring the absentee voters or creditors. I would ignore the abstention and then treat only the creditors who have actually voted either way. That is my position. That's my opinion.
Yeah, sir, agreed with you. But see, this now another my view. See, this decision would be considered when there is a close by voting. So if 60% people have voted, so refer to my example in which I said 70 have voted in favor, 10 against, and 20 remain abstain. What happens if only 10% are voting and 90 remaining abstain?
Of course, that's
So
subject to the minimum
in that
quorum,
scenario,
yes, I agree.
yeah, absolutely. So my interpretation with respect to this situation, when there is a very narrow margin with respect to 66% threshold.
Yeah, as long as the
Otherwise, if it
quorum
is
is
10
present,
and 90, no, even if quorum is there, see, if you are convening a meeting, quorum is there, everything is there. Out of 5 members, only 1 member is voting. And
Quorum
4 are
is
not
only for
voting.
the quorum is only for the meeting, sir, not for the.
Yes. So technically, with this interpretation, what happens if 4 are not voting, 1 is voting, we'll say 100% voted. This is not a fair practice.
correct. It's
So
not a fair practice.
yeah. So permutation combination would be there, and see why so much of deliberation and why I am able to collect all this material, because I have personally faced this situation, and even within a group it has been discussed at length. So the circle in which we are operating, we have discussed this situation at length. So,
Okay. Can it not be that the RP actually takes a call on this and presents it to the adjudicating authority? The adjudicating authority can rule upon this.
Yeah, but
that
see,
would
as far as
prevent,
my I see personally, I don't track case laws because ultimately those case laws are situation specific. So these cases are not a principle. So ultimately, as an RP, you have to take a practical decision making. So I have tried to do some research, but I am not able to find any specific decision with respect to interpretation of this particular, how to calculate the voting outcome.
So therefore,
if any,
it becomes much more important for the RP to take a stand and present it to the
very
court.
true,
Is it
very
not?
true. And probably through ICSI, IPA, we can get the clarification from IBBI as well.
And I think as long as you can convince the court, if you take a stand, you can convince the court about your viewpoint and leave it to the court to finally come out with a decision on that.
So absolutely, sir. So we have to demonstrate that we have made a good amount of effort for getting the voting done. Despite of that, if they are not voting, if I say that I have set up an e-voting, they are not voting, no, that is not right approach. You should demonstrate that you have sent 5 emails, you have sent 5 reminders to the system, so it will have a trail. And accordingly, you have to convince that these people are not voting, so their voting should not be considered.
And also another point, one last point is, if you can convince the court about the reasons behind your taking a particular stand, I think the court will empathize with you. Given that you're an RP, you have a fiduciary duty towards the company first to resolve, to come out with a resolution plan rather than target at liquidation. Liquidation comes last in
True,
the
sir.
list of priority,
Yes.
isn't it? Yeah, thank you, sir.
That is
I
the
rest.
reason. See, law is minimal. You have to demonstrate that you have made enough efforts to come up
Yes.
with appropriate decisions. That you should demonstrate. That's it.
Yeah.
This interpretation is part of legal system, or it is part of commercial wisdom? As per you, I think it is commercial wisdom.
Sir, what happens actually? NCLT is an adjudicating authority, right? So
That is
they
correct, but
are
you know
given specific set.
how quick decisions NCLT is taking. You are also aware about.
I am well.
It is easy to say that we can
and,
convince NCLT. It is very easy to convince NCLT, but it is very hard to face them.
See, to convince NCLT is not difficult, but to get the ruling is very difficult because of the system.
For this interpretation, I am discussing about this interpretation only.
Yeah, practically, sir, I am telling you. See, I have personally
but why RP cannot take decision? Whatever we are discussing, whatever interpretation you are taking, whatever
RP can
I am taking.
No, sir. RP is supposed to take the decision. The problem
I think
is
NCLT would not interfere in that.
No, sir. NCLT won't interfere, but the problem arises when the people who have not voted, if their right is getting prejudicially affected, and then they can approach NCLT, then you would be answerable. If they made you party to the petition that I did not vote, and I did not vote, so actually I was abstained, but my view was I rejected the resolution. And if he moves an IA, then you have to explain why you took this decision.
That is correct. We have to face them. That is not a good, bad idea. But I think that is a commercial wisdom of RP.
Absolutely, sir. It is up to you. You don't need to approach NCLT.
Yes.
So I am telling in one of the matter, what happened, I was appointed as an RP. So it was a replacement of IRP to RP. So this matter came. So some of the members voted in favor. One or two, there were 10 to 12 members committee was there, right? So 6-7 members voted in favor. And I believe 3 members did not vote and 1 more member voted against. So that ratio come at 64%. So now at 64%, what is to be done? Shall committee should go ahead with another meeting, and then so they went ahead, they filed an application, and ultimately at 64% voting in overall, and out of voted 89% were in favor. So NCLT allowed that application and they made the replacement.
Yes.
So when margins are narrow, I believe this principle works. But if it is like 10-90, then it doesn't work.
That is of no use.
Absolutely, sir.
Thank you, sir. Thank you very much.
Sir, this is Apurva here.
Yes, Apurva.
Yeah. So to the best of my knowledge, the Liberty House order and the JP order, they are NCLT has covered this particular point regarding the absenteeism of the member from the CoC.
Okay.
And in that, the pronouncement was that the absent member from the CoC will not be taken into account for calculating the voting percentage. So, I think this point is covered under these two judgments.
So basically, the people who remain abstained, their share was excluded while arriving at the conclusion, right?
Yes.
Okay. So as I said, I have come across some couple of decisions, but it was not very specific. You can share the decision in the chat box, so it would help everyone.
Yeah.
Anything else? This is a workshop, so we can discuss anything now. So my senior Amit ji is there. So he is going to take care of critical aspects. So I am though dealing with general aspects. He will take care of all critical aspects.
Thank you, Jigar Bhai. I think I was just enjoying the very live discussion and very interesting discussion. And with your permission, I'll start from where I think the most critical aspect is taking place. And I think in the entire e-voting discussion, the most critical aspects are two. One with regard to the CIRP process, and one relates to the liquidation process, the recent amendment that has taken place in this 2022 itself, regarding the stakeholders meeting, where you also have to conduct the e-voting, and there are certain challenges which are coming, but that I will come little later. But as Apurv was indicating, absolutely, I'll give you the brief background also as to what has happened. If we recall the judgment of C. Sashidhar, the judgment was very clear with regard to the e-voting, and the judgment was saying, as some of the other gentlemen were also talking, I think Rameshji was talking about the same, that you have to read regulation section 34 in a manner that you don't have to exclude the abstained members. You have to include them for the purpose of counting the 75% voting share. At that time, the law was 75%. Later on, it was reduced to 66%. So that judgment stated very categorically, and that was a Supreme Court ruling, where it was stated that nothing doing, you have to consider the share, voting share as per the voting percentage, not you don't have to exclude the abstained members. Now, I'll just share, Trishna, if you have allowed me to share the screen, I'll put forward two judgments.
Sure, sir. Sure, sir.
Now, can you see the screen?
Yes, sir. It's visible.
All right. So this is a matter again of this is a appeal which was filed before National Company Law Appellate Tribunal and State Justice Mukhopadhyay's order of 2019. Interim application number 1857 of 2019, and company appeal number was 536 of 2019. In the matter of IBBI Bank Limited versus Anuj Jain IRP JP Infratech, and stalwarts had appeared in this matter. For appellant, Mr. Salman Khurshid was appearing, and along with a couple of other people. The order is very interesting, and the order was dated 10th of June 2019. As the voting is on, which is likely to be completed today by 5 p.m., we are not inclined to pass any specific order in the present IA number 1857 of 2019 filed by IBBI Bank Limited. After voting, the decision, if taken in terms of earlier order passed by this appellate tribunal on 17th of May 2019, the resolution professional, instead of placing the matter before the adjudicating authority, will first place the decision of the committee of creditor before this appellate tribunal for the further orders. Now, here comes the relevant part. We make it clear that if any of the financial creditor remains absent from the voting, their voting percentage should not be counted for the purpose of counting the voting shares as held by this appellate tribunal in Tata Steels Limited versus Liberty House Group PT Limited and others. Company appeal insolvency number 198 of 2018, disposed of on 4th of February 2019. So this order, if we see, so what Mr. Jigar was talking about, if you correlate, I think that absolutely gives a clarity that we don't have any other option than to acknowledge the order passed by appellate tribunal, which has not been challenged so far by any of the authorities, which is a law of the land as on date. Somebody can only say that Supreme Court has passed the order in the matter of C. Sashidhar, which being the higher, body should be adhered to. But I believe after that, because the appellate tribunal has passed, considering that particular order also, I'll just place the liberty order wherein the case Ashidhar matter was also discussed. After that, that particular order has been passed. I believe fairly it gives the clarity that we have to consider it this way. Otherwise, the process of CIRP, which is a time bound, will not be able to complete it. And as the justifications and the logic what Mr. Jigar has given, I'm sure are very logical. Even the BLRC committee report mentioning about this particular fact, and the other logics of the different high courts with regard to the voting interpretation, I think those are to be considered for the purpose. And I'll also request if Deepak Raoji is there in this forum as of now also, we have made a separate representation also on this particular subject to give a clarity. In this forum, again, I'll be making a request that to bring this subject to a further clarity, a clarification may be issued by the IBBI with regard to this particular voting interpretation, so that the confusion is not there, because this is the only point where a lot of confusion is there still in the many of the quarters. And as we are having the heated debate today, we are having the debate in every time and corner whenever the CoC meetings are being conducted or the other discussions are taking place. So that is the request that I'm making. Let me just share the judgment of this Tata Steels Limited versus Liberty House also. So this is a judgment which was on 4th of February 2019. Let's see, and here also the stalwarts had appeared for appellant Abhishek Manu Singhvi and Sudipto Sarkar was appearing. And if we see the relevant part, I'll come to this is a little long order, and so this starts with para 45. Now para 45 says a member of the committee of creditor who is not present in the meeting either directly or through video conferencing, and thereby not considered its feasibility and viability, and such other requirements as may be specified by the board, their voting shares therefore cannot be counted for the purpose of counting the voting shares of members of the committee of creditors. Therefore, we hold that the members of committee of creditors who attend the meeting directly or through video conferencing can exercise its voting power after considering the other requirements as may be specified by the board. Those members of the committee of creditor who are absent, their voting shares cannot be counted. We find the resolution plan submitted by JSW Steel has been approved by committee of creditor with 97.12% voting shares, and voters having 2.88 voting shares have remained absent. If some members of the committee of creditors having 2.88% voting share remained absent, it cannot be held that they have considered the feasibility and viability and the other requirements as specified by the board. Therefore, their shares should not have been counted for the purpose of counting the voting shares of the committee of creditor. In fact, 97.12% voting shares of member being present in the meeting of committee of creditor, and all of them have casted vote in favor of JSW Steel. We hold that the resolution plan submitted by JSW Steel has been approved with 100% voting shares. I think with this order by NCLAT, at least I'm having a lot of clarity, and we have been religiously following and adhering to this particular judgment. And as Jigarji was mentioning, though we keep on trying that majority of the CoC members put to the vote. That is the effort required to be made by each and every resolution professional, so that we are not in any of the difficult situation, just to avoid any complexity, because IBBI so far has not came out with any clarification in this particular regard.
Sir,
Now,
pardon me, if
yeah.
member present in the meeting and he absent from the giving vote, yes or no, then how we would consider?
No, even if it will not change the situation, because
there is the member being present in the meeting.
now I understood. Your point is that
present case is the members who are not abstained completely from the meeting. At those things are covered in this judgment.
So let me put it differently. So we are putting three categories. One, who has not participated in the video conferencing meeting at all, and he has not voted. That is one category. Number two category is a member who has participated, but he has not voted.
Yeah.
Number three category, who has participated and who has voted also. So the last category, we don't have any doubt, the person who has participated and voted, or maybe the fourth category who has not participated but voted. So last two categories, we don't have any doubt, because the person who has voted, that means he has considered the commercial viability of the plan, and then he has voted, right? Irrespective whether he has actually read the plan or not, irrespective of that, he'll be considered, because he has voted, he has exercised his wisdom, then he is considered to be aware of what the resolution plan is. Now, first two categories, I will put them in the one basket only. If you read the judgment also, and if you read the spirit also, the person who has participated but has not voted does not mean anything else that he has consciously decided not to vote. If he has absented himself, that means he is no longer interested in participating in the decision-making process. It is his choice decision, that he knows that the decision has to be taken in a time-bound manner. Despite of that, he is abstaining himself. It is not that he is not aware as to when the voting is taking place. He is quite aware that voting is going to take place in next 24 hours of time, and despite of that, he has chosen not to vote. So we'll be putting him into the same category, that will not count him for the purpose of total vote share.
They should be count for the voting share is the High Court decision, your decision.
No.
Or present in the voting, whether he gives the vote in favor or not, or absent. Total voting share, that should be counted.
Two things are different. See, why they have related this particular matter with regard to the persons who were present, just to give a justification. But the person who has presented himself in the video conferencing meeting, who has participated, that means it is a better case that the person who has absented may have an argument that I was not aware about the time and place of the meeting, or I was constrained not to participate. But the person who has participated in the meeting was very well aware about the voting and other details. Despite of that, he has not participated. That means very clearly that he don't intend to put his vote. That is my view. That is how I read the provisions of law as well as the order of NCLAT. I think Vinodji has raised his hand. Please.
Sir, I understand that the member who has not attended the meeting, but he shall be having a right on e-voting. Am I correct, sir?
Absolutely. Absolutely. Everyone is having the voting right. Whether you have participated in the meeting or not, that does not mean that you are debarred from voting. You are having full right to vote.
Thank you, sir. Thank you.
Sir, if you follow the spirit of this judgment, if 10 members are there and 9 have abstained in the meeting having attended and 1 person has voted in favor, what is the position in that case?
So I'll go with if we follow the spirit, maybe if 9 have absented, I will say that they have consciously absented themselves. if they have participated, that means they were knowing that the voting is going to take place, and if I don't put negative vote, then the resolution is going to pass.
No, can you say that it is 100% voting has happened in this, just like in this case?
In my view, yes. I think Jigar ji is having some thought. I think let us hear him out.
Yes, sir. Yeah, with respect to the circulation of e-voting option to the members who did not attend the meeting, right? So if we read the regulation 25, voting by committee, so it has set up a process. So it says, so the resolution professionals shall take a vote of the members of the committee present in the meeting on any item listed for voting after discussion on the same. Okay, the present in the meeting. Then it says, at the conclusion of a vote at the meeting, the resolution professionals shall announce the decision taken on the meeting and so and so. The resolution professionals shall circulate the minutes of the meeting by electronic means to all the members of the committee and the authorized representative. So we have to circulate minutes to all the members, whether they attend or not. But 5B says, seek a vote of the members who did not vote at the meeting on the matters listed for voting by electronic voting system in accordance with regulation 26. So if you do the pure reading, they did not attend, so they are losing their right. So
yeah, correct, sir.
Spirit of the law, obviously we should share. Everyone should be given opportunity to vote, but he has not attended. How will he exercise his right? So this is left up to.
No. I'll tell you how it has to be read. What is the rationale? Means rationale is that the person who has exercised. See, by default, what we do. There is another question. I think I have a judgment of disciplinary committee of IBBI also. I'll share it a little later. What happens? The another critical issue what people are having is it mandatory to have a decision making through e-voting process? Is it mandatory? No.
No, it is not.
It is not. Depends if all the members who have attended the meeting, they have exercised the voting right by show of hand, the chapter ends there itself.
Sir, Mr. Jigar is saying that those who have not attended doesn't have a voting right. That's what it means.
No. Let me come. I'll come to that. So if we agree that the voting right is required to be given, e-voting has to be set up only in situations where the voting process could not be completed in the meeting itself. Now, what is the logic of giving the e-voting facility? E-voting facility is that in many of the situations that you are not able to take immediate decision in the meeting itself, and you want a record to be created. In many of the situations, even if you are able to take decision during the course of meeting, but still the committee of creator want a trail to be created for the purpose of recording for future. So they want the recording to be done by the e-voting itself. In many of the situations, we are having only 2 committee of creators, and they have been in a position to take decisions also then and there itself. They have the sufficient authority, but they have been insisting, no, Amit, we will be going through the e-voting process itself. Let us set up the e-voting. We will put the vote at e-voting. Now, assuming that, because voting right is somewhat a fundamental right to the person who is interested to come forward and cast a vote. Committee of creditor or the resolution professional in its own wisdom should not take away the right what is fundamentally provided to each and every committee of creditor. Just because the person could not participate in the meeting, when the second opportunity was provided to them by way of e-voting, whatever decision, whether he chosen to attend the meeting or not chosen to attend the meeting, the line that you are reading in the regulation 25, which gives an indication that if the voting e-voting to be provided to the person who chosen not to exercise their voting right during the meeting, That does not mean that the persons who have not participated in the meeting are not to be given the voting right. It has not to be read negatively. I believe that, because that is not in the spirit. It is only to give an indication that those who have chosen not to vote are to be given. It is not negative that the persons who have not attended the meeting are not to be given. I think that will be unfair interpretation. I believe that.
Quite true, sir. On the spirit of the law, we should give an opportunity.
We should give the opportunity, and we have been giving, and that has not been.
We have been giving, absolutely.
My view is a person who is not attending and deliberating in the meeting, what view he can take, what happens on some issues approval. Sir, please listen to me.
Yeah.
If a resolution plan approval is being discussed, it's threadbare for 5 to 6 hours or 7 hours, and without attending, if he chooses to vote, if he is given a right to vote, what logic it has, sir?
I'll answer. See, the voting lines are not open only for resolution plan approval. Please understand, it is for all the items. There are n number of items what Mr. Jigar has just
yeah, for that matter, in any case.
Let me allow me to complete. So when I have, and it is not that what discussion has taken place during the meeting that is important. In my own wisdom, I have received the agenda papers. I have evaluated the resolution plan. I have my own view how to put a vote in favor or negative. That is my decision. I need not be influenced by the decision of the other. I need not participate in the meeting. How and why my voting right should be taken away? But I don't understand that the person who has not participated in the meeting, why participation in the meeting is so sacrosanct to exercise the voting right. I may be having my own way to deal with the particular subject, and I'm aware that my view is very clear. So I have decided not to go to the vote. I chosen only to put when the e-voting will be set up, then I will put my vote, and my vote is.
Then I will say that there is no need for conducting any meeting, and agenda circulation is enough.
Meeting is additional, sir. Meeting is additional to facilitate the discussion, to facilitate the exchange of views. Somebody means everybody is not equal. All 5 fingers are different in size, in their own way, or in their behavior. So everybody is given the opportunity. So our role as a resolution professional is to provide the opportunity to the committee of creditors to participate. Whether they participate, now there may be many meetings where CoC members are not discussing at all. Are we saying no, you have to, law has specified that you have to exercise your commercial wisdom, you have to discuss, you have to deliberate. Why you are not deliberating? Can we say so? No, we the few of the committee of creditors meeting where the resolution plan is being discussed, I have seen meeting continuing for 2 days, for 3 days, and the meetings are not getting concluded because of the discussions, and few of the meetings are over in a half an hour of time. Are we going to challenge the methodology by which the committee of creditors members are taking their decisions? I think situations are different for each and every person.
Then
and
IBBI should come out with a clear regulation saying that abstention about the voting rights of the members.
That I am with you. I am with you
because why leave this important and critical subject ambiguity?
I'm with you, and if Deepak ji is not there, Trishla, I'll request you to just make a small note of it, and this should definitely grow from ICSI IIP to the IBBI as a outcome of this workshop, that it was strongly requested by both the panelists and all the members present that this point should be clarified with regard to the abstaining, whether that has to be considered or not considered, and we can refer both of these judgment and K. Shashidhar judgment also along with.
All right.
I think that will help, and that is very much required. I think every quarter, whenever we are having a study circle meeting or otherwise we are discussing, this is one of the point of debate where we are stuck, and we always keep arguing for hours on this particular subject.
Sir, on one hand, we say that everything should be kept simple, CoC minutes, planes, drafts, everything. But whereas when it comes to act and regulations, it is getting so complicated.
See, because complications arises because of the different situations, and situations are no law is perfect, and nobody is able to perceive everything beforehand. That's what the challenge is. When the law is drafted, it is drafted by a couple of peoples, and when it is tested, when it is applied by lakhs of people. So it becomes at times a challenge that you could not perceive the way it was supposed to be. Now, many of the things are required to be modified in last 5.5 years of insolvency and bankruptcy code. That is what we have learned. I think you are right, but yes, it's about preempting all the things, which is many times very difficult. So that's how the requirement comes.
This is a very important aspect, and almost 5 years are over, and still clarity has to come on this.
I fully agree. I fully agree. I don't have any doubt, because this puts, especially the way IBBI is dealing with the insolvency professionals in the disciplinary matter. I think it's a matter of concern for all of us. Tomorrow, none of us should get caught into any of the undesirable situation because of taking a wrong stand, or the stand which is not as per IBBI a correct stand. I think will certainly require a clarification. From
that when it was originally written, it was not envisaged, but later on, so many decisions have come and precedents have been established. Then they can come up with an amendment to these things.
No, certainly, I think goes without saying. I think this point definitely requires a clarification from IBBI, and institute should take lead in pushing it to the IBBI that whatever way. But if they say no, absentee has to be included, we are okay with that. But at least a clarity should be there that what has to be followed. We are not on the particular interpretation part. We respect K. Shashidhar judgment also, and we respect the NCLAT, both of these judgments also, and we respect what the other clarifications have been provided by the different forums as well. So this part, I think, is over. Let me also. I have one more aspect. Let me just share one more thing. Are you able to see the screen?
Yes, sir.
Yes, sir.
All right. Thank you. So I'll not run through the presentation. I think majority of the part has been covered by Jigarji, but I'll just highlight whatever I feel that may give further clarity. I think it is little faded. If I can just divide the voting under IBC, it is primarily in the two part. One is during CIRP, one is during liquidation. Now, during CIRP, if you see, there can be a physical voting, there can be e-voting, and there can be voting in case of class of creditors. Now, if physical voting is there, then provisions with regard to the regulation 25 of CIRP regulations are there, which are in picture. E-voting, again, there is a regulation 25, 25A, 26, which is required to be dealt into. And in case of authorized representative, there is a voting by authorized representative, and regulation 25A read with the regulation 26 comes into picture. And in case of liquidation, there can be a physical voting and there can be a electronic voting. So there is again absolute clarity with regard to that electronic voting or physical voting both can take place in there also. If we come to the legal framework part, although Jigarji has very clearly mentioned as to what are the regulations which are required to be dealt into, regulation 25, 25A, 26 are the primary regulation which are dealing with this particular subject. Very briefly, 25 says the resolution professional is required to take a vote of members of committee present in the meeting on any of the item listed for voting after discussion on the same. Now, part 2 says that at the conclusion of vote at the meeting, the resolution professional is required to announce the decision taken on items along with the names of members of the committee who voted for or against the decision or abstained from the voting. I think this is again a very, very important takeaway for all the resolution professionals to ensure that this part is being religiously followed. Because in couple of disciplinary proceedings, we have noted that though no adverse order has been passed, but the member has observed that it is noted that many of the particular resolution professional has not has failed to comply with this particular regulation also. So even nobody can question otherwise, but or CoC member is not asking you, or they may be feeling it is undesirable, but still RP should religiously follow this particular practice as per the provisions of law, because this is a very clear mention. Then RP is also required to seek a vote of members who did not vote at the meeting of matters on the matters listed for voting by electronic voting system. This is a provision what me and Jigarji was just now talking about. And there is another critical issue with regard to this, the voting to remain open for at least 24 hours from circulation of the minutes. Now, minutes are circulated within 48 hours. And your committee of creditor is making you a request as to please set up voting only after 1 week. How to deal with that? What is your take on that, and how to comply with the provisions of law? Any inputs from any of the members' side, because it says voting to remain open for at least, are we, suppose the meeting took place today. Now we are in a meeting today, committee of creditor meeting has concluded, and now voting has to be set up.
In
and
99% of the cases, it is getting extended even up to 1 month also.
Yeah, that is what I think IBBI has also observed in many of the disciplinary matters, that and they have came up heavily on the committee of creditors also, and a code of conduct was issued by the IBBI, which was supposed to be enforced in the format in which it was released, but I believe still it is in process, and that has not came up. So nothing against committee of creditor members, but ultimately the question comes on the functioning of the resolution professional. How to deal with such kind of situation where you are getting a clear instructions from the committee of creditors that please set up the voting maybe a 1 week later or 10 days later because they don't have a necessary approval in place. How to deal with that? I'll request Jigarji's view also on this particular subject, and maybe if somebody has any other person also has any view on this, let us have a discussion on this, because it's a very common question and very, very common challenge that we all RPs are having.
The voting
Yes,
window
sir.
can be set up and the times can be extended. So that's what I feel. And there is no point in postponing the setting up the window itself, because at least one part will be taking care as per the act and regulations.
So you mean to say you have circulated the minutes within 48 hours and after that
and we open the window
and the voting
and fix a date, and if anybody extends, then send a mail to all the members, so and so members, still some of the members are yet to vote and we are extending as per their request by another 2 days, 3 days or a week. And it should be done based on the time available for the entire process. So if sufficient time is available, a slight leverage can be taken. But if the last day for filing of the resolution plan with the adjudicating authority is the next day, and then if these people are coming with extension, then there is no point, because it has to be taken in a much faster manner and well in advance.
Yeah. Any take, Jigarji?
Right. Yes, what Srinivasan ji spoke quite logical. See what happens, minimum 24 hours we are supposed to give. So as soon as we circulate the minutes of the meeting, we are supposed to activate the e-voting. So even I discussed during my conversation that during the meeting itself, we should decide if they are going ahead with the e-voting, then a time frame should be decided in the meeting itself. You want 1 week? Okay, fine. We are giving 1 week, because ultimately consensus should be there. If one member is not voting and he is seeking extension, so others have voted. So technically they should, if voting timeline was on higher side, they would have got a larger time to decide upon. So we should give one opportunity to extend, but the time frame should be decided in a meeting itself. Then give one more opportunity, then consider them abstain.
So we agree that voting lines will open as per our schedule, as per the legal schedule, and we may continue to have a larger period, larger voting window period for the purpose of enabling the exercise of voting right by the committee of creditors.
Yes.
Instead of delaying the setting up of, because that is also a practice. So just a correction for those who are following the other way, because I agree, my personal view is also that, because why you yourself are putting yourself into the non-compliance danger.
Yes, you have to initiate.
You have to comply, you initiate now, because you have got the specific mandate from the committee of creditor, which is recorded in the minutes also in black and white. And basis that, of course, what Srinivasan is saying, that if you have a very short window available, then you in any case have to push the committee of creditor that no, we cannot have it 15 days. We have to complete that in a 5 days or 10 days period, so that we can comply the timelines also. I think that is a fair view that we can take up. All right. I think another important part which comes for in challenge is with regard to the authorized representative. Let's say there are class of creditors available in the particular case, and it's a case of a, let's say, home buyers. So of course the meeting which is taking place with regard to the committee of creditor, and there are two voting windows which are required to be set up. One for a class of creditor members, which is generally done by the authorized representative, but practically we have been seeing that the resolution professional itself is setting up the voting window for the authorized representative cases also. Now, second voting window will be for the committee of creditors itself. Now, how to deal with the timelines which are required to be dealt with regard to that. And in that particular case, I think the law is very clear. I'll draw the attention of Jigarji also. Here, the people who have absented in case of authorized representative, that is the class of creditors meeting. If class meeting is taking place, the people who have voted are only to be counted for the purpose of deciding the majority vote, to decide as to what the authorized representative will vote upon in the committee of creditors meeting. The absentee confusion is not there in the case of class meeting, class of creditor, which is prevailing in the case of CoC meeting. Is that right, Jigarji?
Perfect, sir. So we can get a reference from that. Over there, it is very clear.
Yeah, regulations are very clear, and those regulations are very clearly mentioning about this particular aspect. So any confusion with regard to the AR part, if anyone is having with regard to the e-voting, because here two e-votings are set up, one for the class of creditor, and then subsequently the creditors committee of creditors meeting, the e-voting setup is done. Timelines are like they have prescribed the timeline in the same manner. For class of creditor meeting, the timeline is like at least 24-hour window is required to be open, and for them, for the other them, it is 24 hours. And there is some timeline that at least 24 hours before also you need to tell to the class of creditors also.
The expenses of e-voting for the authorized representative and all are how they form part of these.
They are part of CIRP cost. Those expenses are part of CIRP cost. There is no ambiguity with it. That is a process cost, and that will be borne by the CIRP as a CIRP cost only.
And the infrastructure provision of providing e-window to the class of creditors and all will be taken care by the authorized representative.
Practically law is saying so, but practically whatever I have dealt so far, it is being provided for ease of, because he in any case is already taking a e-voting platform. So they have even many of the platforms have enabled a child platform there itself for the purpose of class of creditor meeting also. So automatically process is being set up, and it includes the cost of class of creditor meeting also wherever it is required. So practically I am saying ki AR is not taking the separate infrastructure, and he's not incurring a separate cost for the same. It is dealt by the resolution professional itself. That is my personal experience. If anyone has got a different experience, I'll be able to discuss that as well. So as far as we will discuss a little more on the AR part, because I believe when we are dealing, so means whom to recognize, whom not to recognize is a bigger challenge. Now we are talking only about one class of creditor, but let us understand which all authorized representative can be there as far as the voting rights are concerned. So if there is a consortium arrangement, and or there is a syndicated facility, and the arrangement provides for appointment of a single trustee or agent, then such trustee or agent may be appointed as a authorized representative. This is a very common issue which is being handled by all the big cases where the consortium financing is there. That as to who you will recognize for the purpose of giving the e-voting right. There are, let's say, 3 consortium, 3 bankers. Punjab National Bank is there, State Bank of India is there, Bank of Baroda is there. Now, they all are sending their respective representatives, and they all are saying ki I want my voting right to be exercised by respective banks. BOB wants their voting right separate, PNB want their voting right separate in the voting share manner, and State Bank of India also want the separate. Should we recognize that? Answer is yes. There is nothing in the law. Law enables for appointment of a single trustee if the consortium agreement provides so. If consortium agreement is not providing so, then we have to in any case provide separate voting right only. But it is the other way. If consortium agreement says that they can appoint a single trustee, single agent, the single person can also act. Otherwise, by default, they can appoint a single IRP also. They can appoint a single trustee agent also. They can represent on their own also, and one can represent on the behalf of the other also.
Normally, in all consortiums, trusteeship will always be there.
Yeah, it is there. Now, question why question is there? Question is that they have a provision that a single trustee will be there, right? Now, when it comes to committee of creditor, they say, State Bank of India say, no, we want my representative to be there in the meeting. We want my person to be present in the voting right, or my person will separately exercise the voting right. Should we recognize that or not? Is a question, is a critical issue. So answer is that there can be two situations. If consortium agreement does not provide for appointment of a single trustee, then in any case it has to be separate. Now, if it provides, then there is an enabling provision that yes, in that case, single person can also be there. Otherwise, by default, it has to be separate only. That is what the point of discussion is. So if State Bank of India or BOB or PNB is asking for a separate voting window or separate voting share in the CoC, then there is nothing wrong. We have to acknowledge that, we have to honor that, and we have to provide that.
Sir, as per my experience goes, these trusteeship agents are only mere security trustees who keep the documents and other pledge of shares and other mortgage documents. They don't have any knowledge of this credit appraisal or credit dispersal or follow-up and all. So that's why committee of creditors, being the main lenders, they take care of the voting. Normally, they will not allow the security trustee to vote in the CoC meeting because they don't have any expertise of dealing with this.
No, in couple of cases, I'll not say ki it is not happening in any of the case, but in many of the cases, the consortium has appointed a trustee, and they have been representing themselves in the CoC meeting also. But the law is saying that that can be done only if the consortium arrangement or the agreement provides for the appointment of single trustee. If that is there, then they will recognize. Otherwise, in any case, by default, the separate lender will be recognized separately as per their voting share. That's the provision that
here I have a small thing.
Yeah.
Though you should not feel like getting elaborated on this subject, but the claims are coming from different creditors, even though it is a consortium.
Claims are coming from
individual lenders.
No, I agree. In many of the situation, even claims are being filed through the trustees only. That is what it is an enabling provision. Filing separately is nowhere barred.
Yeah, correct.
It is
normally when it comes to admitting the corporate data to a CIRP process, everybody wants to part ways with the consortium.
Absolutely, that is what practically is being
on their own.
Yes, absolutely. And similar provision is being exercised for the financial debt, where the debt is in form of a securities or deposits, and the terms of appointment are providing for appointment of a trustee. Then the same person will be acting as a authorized representative.
Consortium arrangement is only when the company is in good times.
Yes, absolutely. Now, we have already discussed the class of creator situation, that the AR is being appointed by making an application to the adjudicating authority, and due process is required to be followed for the purpose of appointment of a authorized representative, and he exercises his rights as regards the participation in the meeting and as well as the voting right also. Similarly, for a case of a guardian, executor, administrator, also, because in such cases also you have to see the validity of the person who is coming forward. Now, in case of a minor, in case of administrator, or in case of companies which are already in CIRP, it is to be represented by the authorized person or the authorized representative who is having due power. So, point that is required to be taken care is in many of the situation we are not able to do necessary due diligence with regard to the authority to come forward and represent in the CoC meetings and authority to cast their vote in the e-voting platform. So that has to be verified thoroughly to avoid yourself from the challenges what can come tomorrow. Now, as far as e-voting is concerned, there is only one regulation, that is regulation 26, that deals with, which has been dealt with by Jigarji. We'll just see if there is any criticality involved in any of these provisions also. RP has to provide each member of the committee the means to exercise its vote by either electronic means or through electronic voting system in accordance with provisions of this regulation. So this language also gives me the comfort that the view that I'm taking, that each and every member of the committee has to be given the voting right, is also coming from regulation 26. And of course, at the end of the voting period, the voting portal will be enabled to block the further voting provisions. And at the conclusion, this announcement we have already discussed, very critical one. The resolution professional shall circulate a copy of record made under sub-regulation 4 to all the participants by electronic means within 24 hours of the conclusion of voting. This is also an important point, well dealt by Jigarji as well, that this record has to be created and you have to circulate it by way of a electronic mode itself. Now we come to the last part of the legal framework, where regulation 31A of the liquidation regulation is important, and let us understand what it talks about. The stakeholder consultation committee it deals with, and the liquidator is required to constitute the consultation committee, which will comprise of all creditors of CD within 60 days from the liquidation commencement date. It will be as per the list of stakeholder which is prepared in terms of the provisions of regulation 31 to advise on primarily 5 matters. What is the remuneration payable to the professionals who are appointed under the liquidation? Sale under regulation 32, manner of sale, pre-bid qualification, reserve price, marketing strategy, auction process, fees of liquidator, and the valuations which are required as per regulation 35(2), and the manner in which the proceedings in respect of preferential transaction, undervalued transaction, extortionate credit transaction, fraudulent or unfair wrongful trading are required to be taken. Now, so on these 5 matters, the decisions are required to be taken, and the stakeholder consultation committee, this we are aware. Now, 1A provides that the committee of creditor under section 21 shall function as a consultation committee with the same voting rights till constitution of consultation committee under sub-regulation 1. This is a time gap arrangement. Now, 2 is important. 2 says the voting share of member of the consultation committee shall be in proportion to his admitted claim in the total admitted claim, provided a secured creditor who has not relinquished his security interest under section 52 shall not be part of the consultation committee. Then again, proviso 2 says the promoters, directors, partners, or their representative may attend the meeting of consultation committee, but shall not have a right to vote. Further, financial creditor or his representative, if he is related party, he shall also not have a voting right. This is a provision that 35(2) deals with. Now, liquidator has to facilitate the stakeholder of each class, namely financial creditor in class, workmen, employees, government department, other operational creditor, stakeholders, partners, to nominate their representative for participation in the consultation committee. This is one part on which I'm flagging. And last is if the stakeholder of any class fail to nominate their representative under sub-regulation 3, such representatives shall be selected by majority of the voting share of the class present and voting. Now, in this backdrop, there is a regulation 4A which has also been inserted. The representative under sub-regulation 3 or 4 shall vote in proportion to voting share of the stakeholder they represent. Last is subject to provisions of this code and these regulation, representative in consultation committee shall have access to this, provide them the access to all their records. Now, let us understand what the challenge is with regard to the liquidation. Now, law provides that voting right to each class. Provision is not clear as to who shall be nominated as representative of each class. Whether representative should be selected on the basis of highest amount of claim or otherwise. Now, there can be instances where the claims are huge in number, such as workmen, employee category, who might not have mentioned their credential or their details with regard to the phone number, with regard to their email in the claim form. How the liquidator will be able to reach out to them? I want little guidance from IBBI in this particular regard, to have a clarity as to how this process practically will be required to be followed. If anybody is already dealing with the subject, I'll request him to throw some light so we can discuss and deliberate as to what are the challenges in this regard. And if somebody has any more challenges which one can envisage, these are few things which I think are little critical and are required to be sorted by IBBI at the earliest in view of the recent changes what IBBI has done. Now we can make further discussions on these liquidation provisions as well. I think the other critical aspect in respect of CIRP we have already dealt into. Yeah, maybe I'll request Jigar ji also to share his thoughts on this, the challenges on the liquidation part.
Absolutely, sir. This is not a tested regime yet because it has come from October itself. It is hardly 2 months. People have just reconstituted the SCC. So probably who will be the authorized representative, that is a task to decide. I believe in the regulation it is mentioned we have to facilitate. So probably we have to coordinate with all the people who are having the highest claim ratio, and within them they should nominate someone. But practically in one situation, there is one Kolkata-based company wherein large number of operational creditors are there. So we consulted them that you become the lead member for the entire group. So we consulted them, and then
question is what should be the basis, whether it is the amount that will be decided?
Amount, yes, of course, sir. Ultimately, it's your stake which is on higher side. So basically, you will take the best decision. That is what, even in a committee meeting, what happens when whosoever is having highest voting share, they only drive and they only hijack all the discussions. So technically, the quantum of the share should be taken into consideration. Probably in that matter, we represented that the highest number of claimants were from specific region. So out of 100 rupees, 30 rupees stake with a 70% representation. So if you see Pareto principle, the highest number of people were in one specific region. So we recommended that the authorized representative should be from that region.
Okay.
So it was a Kolkata-based company, and the maximum number of claimants were based out of Gujarat. So we represented to the RP that you should allow us the opportunity to represent. So it is yet not settled. Let's see.
All right. I think the point why I have flagged this particular point is because IBBI is to be made aware about all these challenges. And because they have made the regulation, and now it is part and parcel of the law of the land, and we are duty bound to comply with this particular provisions also. And tomorrow again, we should not land up into some of the trouble because of the ignorance or because of the inadvertent intentions that we have taken. So my request again to ICSI is to make a proper representation on this particular part also, and seek necessary clarification, because this part necessarily requires some more clarity so that each and every liquidator is in a position to take a necessary step to appoint the right authorized representative wherever it is required. Until that clarity is coming, I think we all will continue to do at our own basis whatever best judgment we are able to apply, as Jigar ji is mentioning, basis the claim, and basis considering the people who are going to be the best bet in particular region, who are going to be able to represent them in a best possible manner. I think these principles can be followed. Few more, if anyone has got a different view, I think I'll take that also. Otherwise, this issue, I think we have already discussed.
I think still the liquidator has a choice to differ from the opinion of the still.
Yeah, he has, but he has a very strong reasons to give a justification as to why he is not following the recommendation of the stakeholder consultation committee. That's what he has to record the reasons, perhaps what I understand, if he is deferring to the provisions with this particular regard.
Yeah, now they have added that we are supposed to inform it to the board as well as adjudicating authority. That's why we are deferring the decision. And now recently IBBI has also come up with that specific format, and it is now activated in our IBBI login itself. So whenever there is a liquidation assignment, it is having an option to just open up the form and fill up the details.
Yeah, so I'll discuss one very interesting order of IBBI, which was passed on 21st of November 2022, exactly about a month back only. And it was on e-voting. So I thought it is little relevant and we should spend some time, although not very directly, but yes. It is important that we understand the entire matter. So we'll spend some 5-10 minutes time to understand as to what the matter is. Then only we'll be able to appreciate. So regulation 34 of CIRP regulation, which deals with RP cost provides that CoC shall fix the expenses to be incurred on or by the resolution professional, and the expenses shall constitute insolvency resolution process cost. Now, board observed from the minutes of the second meeting of Committee of Creditors dated 10th of December 2019 that one of the agenda as discussed in the meeting was to ratify the IRP cost incurred during the CIRP of CD. The minutes further states that CoC members decided not to put on e-voting in order to save the cost and to send details of CIRP cost by email for seeking internal approval and convey the same accordingly. Last line is very important. The minutes further state that CoC members decided not to put on e-voting in order to save the cost and to send details of CIRP cost by email for seeking internal approval and convey the same accordingly. Board, however, observed that the minutes of subsequent CoC meetings do not mention or even indicate approval of the said CIRP cost by Committee of Creditors. Now, in view of the above, board held that prima facie view, Mr. Sunil Kumar Agrawal has inter alia violated section 2082A of the code, regulation 34 of CIRP regulation, regulation 72A, 72H of IP regulation, which is standard, read with clause 124 of the 1214-16 of the Code of Conduct. These are standard clauses of the Code of Conduct in which we are generally trapped into. Now, IRP submitted that he placed the data of expenses in first CoC meeting aggregating to rupees X. The same was duly ratified by Committee of Creditors in physical meeting. Since HDFC was sole CoC member, HDFC Bank was sole CoC member till time of the second CoC meeting dated 10th of December 2019, where he placed the details of expenses till date and recurring in nature thereafter. CoC decided not to put e-voting to save cost of conducting e-voting and decided to send the same through email after taking internal approvals. Now, let us distinguish the case. Had the case been that HDFC has attended the meeting and taken the decision in the meeting itself, the e-voting was not required at all. I believe in this particular case, HDFC was not having necessary authority, the person who participated in the meeting. So e-voting was decided to be taken, but instead of taking the e-voting platform, the HDFC Bank suggested that to give the voting by the email itself. That's the entire point in debate, if I'm understanding correctly after reading the order. Now, the lead or sole Committee of Creditor member provided specific approvals on email and other costs, including recurring in nature, on letterhead of HDFC Bank, duly signed by the official who attended the CoC meeting. IP fees was approved by HDFC Bank, wide email dated so-and-so. The appointment of forensic auditor was done by issuing email letter dated so-and-so in consultation with the sole CoC member, was specifically ratified by the physical letter thereafter. Further, the claim was received from ICICI Bank on 20th of December 2019, and thereafter the Committee of Creditor was reconstituted. Now, IRP further submitted that for disbursement, payment of pending amount, detailed deliberation took place in all forthcoming CoC meeting. However, other CoC members who were inducted in CoC later never challenged these approvals of CIRP cost of previous CoC meetings in forthcoming CoC meetings. However, delayed the payment maybe for one or the other reasons which is on record. IRP submitted that all CIRP expenses, approximately 38.52 lakhs, after adjusting 8.25 lakhs recovered from CD2 bank account, were incurred from his pocket, ensuring a smooth running of process even during COVID-19. Sought proof transaction and got transaction reversed by the court order. And CoC members miserably failed to fund CIRP costs till adjudicating authority ordered recently. He had to run from pillar to post to get back CIRP costs from the CoC member. However, till date, not able to recover the full amount. IRP submitted that it is HDFC Bank who requested Mr. Agrawal to send proposals for ratification of bills for expenses as CIRP cost through emails for taking internal approvals, and by doing so, it has violated circulars guidelines of IBBI that individual members coming to CoC meetings should have full powers to decide on the spot and not defer decisions proposed to be taken in the CoC meetings, as IBC is a time-bound process. This was exactly the same thing what Mr. Jigar was highlighting with regard to the IBBI circular of 2018. This is in black and white, and this time and again IBBI has been emphasizing, but unfortunately the CoC members are still not very much aware, or they are not able to adhere to this particular provision, and ultimately it is causing a difficult situation for the resolution professional. In this matter also, it is not the resolution professional who was primarily at a mistake, but because of the whims and fancies of the committee of creators, the challenges came before him. Now the matter of non-payment of CIRP expenses in the IA number 885 of 2021 filed before the adjudicating authority was decided, and CoC has already paid over 21 lakh, only part amount is left. Now let us see what the observation of DC was. DC notes that the approval of expenses placed for approval in the first CoC meeting was approved by the HDFC Bank, who was sole CoC member during that time. Further, HDFC Bank sole CoC member during second CoC meeting also gave approval for appointment of forensic auditor and other appointments as deemed necessary to Mr. Sunil Kumar Agrawal. However, the expenses like traveling, lodging, boarding, conveyance expenses of RP team and professional accounting firm fee, forensic audit fees, meeting hall charges, security expenses were not accorded specific approval by HDFC Bank, sole CoC member during or after second CoC meeting. DC notes that CoC has ratified fees and expenses of IRP after deliberation, other than those which are not substantiated with proper information, documents such as above. DC observes that HDFC has passed resolution for appointment of forensic auditor and authorized Sunil Kumar Agrawal to appoint other professional. Further, the expenses were deliberated by CoC, not approved for lack of substantiation. The issue is pending before the adjudicating authority for final adjudication. DC also notes that IRP has referred expenses to CoC for ratification. Hence, DC found that contravention reported is more of a procedural nature, and it's nobody's case that it has been done with any of the malified intent. Now, further it says the code is structured around time-bound resolution of the corporate debtor. Any stakeholder does not have liberty to interpret the provisions which are contrary to the intent on the grounds that in his or her understanding explicit provision do not warrant a particular action. seeking extension of time on expiry of deadline is essential requirement, and in normal course, RP is in a position to nudge the CoC to take appropriate decision as per the stipulations of the code. Even if CoC is not cooperating, RP has a responsibility to approach adjudicating authority for seeking direction for moving the case for liquidation or not, as CoC in a particular case is not cooperating in making its mandate available. In respect of CD, as per the facts available, the meeting of CoC was convened by IRP. However, perusal of draft agenda indicates that item related to seeking extension of time beyond 270 days was not included. This is indicative of the fact that IRP was no way interested to push the agenda for extension of time. It is immaterial whether this scheduled meeting held or not. Timelines for the process as enshrined in the code needed to be followed. The value maximization maxim mandates that all efforts are required to be put in place for resolution, failing which the liquidation can be pursued. This is rather bad example that both RP and CoC work towards pushing the CD into liquidation on the technical grounds. And lastly, the DC in exercise of powers of 220 of the code, read with regulation 11 of IP regulation and regulation 13 of the IP inspection regulation, issues the direction as under: IRP shall pay penalty of X amount and deposit the penalty amount directly to the Consolidated Fund of India under the head penalty imposed by IBBI within 45 days. In addition, he will be working as a probationer for 4 months and with the other experienced IP so nominated by her IPA under which he is registered. Till completion of this probation, AFA will remain suspended and he will not be able to take fresh assignment. IRP is directed to be more careful and cautious while dealing with the assignments under the code and regulation made thereunder. Further, it goes on saying the para that CoC has been enabled under the code like board of directors to take the decisions in respect of CD during CIRP. The most important duty casted upon CoC is to assess the viability and feasibility of the resolution plan with objective to continue CD as a going concern, maximize the value of the assets of CD, and that the interest of all stakeholders, including operational creditor, are being taken care of. Supreme Court in the matter of K. Shashidhar versus IOB held that legislature, while enacting the code, has consciously ensured that no ground is available to question the commercial wisdom of the individual financial creditor or the collective decision of the CoC before the adjudicating authority in approving or rejecting the resolution plan, and such commercial consideration are outside the scope of judicial review. The Apex Court has further observed that AA cannot interfere on merits with the commercial decision taken by the CoC, and limited judicial review is available. Considering such responsibility and accountability endowed with CoC, therefore onus of responsibility to put sincere effort in place to prioritize the resolution as a going concern are on the resolution professional. So this is a long and short crux of what IBBI has been time and again emphasizing on the various disciplinary matters. I have just shared one of the matter, but there are n number of matters. I can say at least 5 or 6 matters I can recall. I can share the judgments also, where e-voting issues have also been deliberated, maybe not directly but indirectly, and we need to be giving a due care to this particular process of e-voting so that we can complete this entire process in a due period of time. Now, I'll be happy to take a few more questions, although I think Jigarji has taken all the questions in the first half itself. So I'll still open the session for the question answer, and anyone can raise
Yeah,
and
just to add to that DC order, sir, which we were discussing. So this matter has been challenged in the High Court, and High Court has given stay on this DC order. So RP also presented his view that he did whatever best possible effort he can make, and he has performed all his duties. So this order has been stayed.
Yeah.
Because I know the RP, so I'm aware about this entire incident.
Right. That's a, so point well noted. Now only academic debate, if we do now, academic debate is the, I think, limited question was on the instructions of committee of creditor. The RP instead of setting up a e-voting, allowed the email voting. I think that's a limited part which comes to my mind as an academician, that whether that was justified or not. Maybe somebody can say yes, in the spirit of law, when only one person is there, what is the ultimately the same purpose that what I'm going to achieve is by e-voting also. If you are going to save some 5,000-6,000 of money, and why only one? There may be series of meetings. There may be, let's say there are 10 meetings, you may save 50,000. So every penny counts. So
yes, absolutely.
you can say logically, yes, you are achieving the same purpose. So really does not matter. But yes, the way law has been drafted, the way the law has been interpreted by the regulators, I think it may be a little difficult call by the professionals to take such kind of liberal interpretation. That what my take is, that maybe whatever is the outcome, I wish High Court gives necessary relief to the RP also. I will emphasize that IBBI also need to be little considerate while passing these orders. One should not be more mechanical. I think what is the purpose and the rationale, I think that needs to be, the order need to be little more judicial rather than merely on a technical clutches. We are all in a learning phase. Hand holding is required to be given to the IPs so that they can have a confidence and they can come forward for taking up the assignments. It should not just to means discourage the peoples. I think these kind of orders many a time discourages the members who are entering into the profession. We are already there in the profession for the 5-6 years, so we still are there, but new members are little discouraged with such kind of order. That's a limited submission. I think we can.
Had he noted in the CoC minutes itself with the signature of the sole financial creditor, saying that there is no need for e-voting as long as
If e-voting was not required, there was no mistake. That's what we discussed in the very upfront itself, that e-voting is not mandatory. E-voting is triggered only when the decision is not taken on the items on which voting is required. There are items on which the voting is not required. As we prepare the agenda, and many of the items are not requiring the e-voting. In that case, you are not required to go for e-voting at all. And even the item is requiring e-voting, but you have taken, even the item require voting and you have taken voting by show of hand, no e-voting is required. Yes. So had he recorded in the meeting itself, nothing was wrong. Yes, Srinivasi. So, any more inputs? Maybe I think a lot of people are there. A lot of seniors I can see who have been handling many more assignments than what I have been doing. So I'll request for any particular part, especially when we are having a discussion today on the committee of creditor decision-making process and especially the e-voting. Any critical challenge, any critical issue that might have cropped up before you, you may share so that we can also benefit from the same.
The only issue is postponement of decisions by CoC members seeking under the guise of seeking approval from the higher ups.
Yeah, that I think we have discussed enough, that we have taken a stand that IRP or RP should continue his duty, whatever is prescribed in the law, and he should set up the e-voting as per the timelines. Maybe the closing timeline or the voting window may be little more extended to facilitate the participation by the committee of creator, and as advised by Jigarji, that such decision of extended voting window should also be recorded in the minutes itself, so that it is going to save your skin tomorrow if IBBI is raising some issue or some litigation starts tomorrow. That's
what I liked in the Jigar's presentation is he has mentioned some points where IRP or RP should take a voting on certain aspects. That list is very good. Please share that presentation, Jigar.
Yeah, sure, sir. I will share.
Because many of them miss to take the approval of the CoC by a voting, which requires the voting.
So anything else that anybody wants to submit or share?
Thank you, Amit and Jigar, for an interactive session on the subject. And thanks a lot for both of you.
So Trishla, it is now your turns. I think we have tried to do justice with whatever understanding we have with regard to this subject, but we still are in a learning mode only, and it was indeed a pleasure to listen Jigarji, and the interaction what the learned professionals have done. This has enriched me definitely on many of the account, and it was useful session, I must say. And thanks to ICSI, IPA for giving this opportunity to come forward and interact with all of you. Thank you.
Thank you so much, sir.
Absolutely, sir. Trishla, just a second. Thank you so much. Actually, it has been a good learning session, and obviously, when yesterday I spoke to Amitji, we discussed that what all content we need to discuss, because even we have never thought of so much in detail for e-voting portion. So because of this workshop, we had a good deliberation, and then we came up with okay, fine, we should discuss this major point. But so truly, your experience was reflected, Amitji. Your vast experience was reflected in your talk. So we have gained good understanding of the process from your end. Thank you so much.
Thank you so much, sir. Thank you, Amitji.
Krishna, one more question. You will be sharing any course attendance certificate or something like that?
Pardon, sir?
No. Will you be sending any course attendance certificate or something like that to all the members?
Yes, a mailer will be sent once it's over. Tomorrow, it will be sent by the evening.
Okay, thank you.
Thank you so much, Amit sir, and thank you so much, Jigar sir, for being here today. And this was, I believe, it was a very undiscovered topic. We were receiving queries from IPs, so we thought that it would be interesting to take this subject for discussion. And I think you both have explained it in detail.
So all credit goes to Trishla, who has discovered this undiscovered topic, I think. So this was it never came to my mind that we can have a session on this also. I have presentation on many of the subject, but this is first time when I'm taking an exclusive session on this particular topic. This was so very small subject that we never paid any heed to, that we need to discuss or deliberate on this particular topic. So thanks to you, in fact, and we must appreciate that you have been doing a wonderful job in discovering and doing the research on the insolvency and bringing out the subject which requires the attention for all of us. Thanks indeed.
Thank you, sir. Thank you so much, sir. Thanks to all the participants as well.
Thank you.
Thank you.